The Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Well, good morning. Please have a seat. I see you all brave the weather out there. Welcome to the 4th Department. Just a couple reminders. If you can, remember that the panel is familiar with the facts, so we don't need the statement of the facts unless we ask you for it. And if you can, to the best of your ability and in fairness to your clients, try to focus on your key contentions for us. And don't forget, too, that if need be, you can always submit a post-argument submission. We're not encouraging such an action, but if you need to, depending on what occurs in oral argument, you can apply for that. So with that, we'll start with case number 61, People v. Robinson.
Good morning, Justices. May it please the court. As this court held in People v. Johnson, this case is not meaningfully distinguishable from People v. Moore, and therefore this court should find that the trial court erred in failing to suppress the evidence and ultimately dismiss the indictment.
Counselor?
Yes.
Might as well get this right out of the box. The Court of Appeals decided a case in November of last year called Leighton R.
Correct.
That seems to kind of set the standard for us. Would you agree?
I would agree that it makes clear what test the court should use, and the court ruled in Leighton R that the court should consider totality of the circumstances. However, in Leighton R, the court also stated that Aguilar-Spinelli is certainly part of that analysis.
In terms of reliability?
In terms of the totality of the circumstances, one of the factors the court should consider is Aguilar-Spinelli.
But Johnson also had an expression in it with respect to referring to concealed criminal conduct. And you probably picked up on the fact in the Leighton R, the Court of Appeals said it can be non-criminal conduct. It also provides reliability as part of the totality of the circumstances. So once Leighton R sort of sets a standard for totality, that does seem to mimic what the county court cited, or Supreme Court, in its decision on People versus Moss.
Right, but
that had the same standard there. Go ahead.
Yes. The court rejected the People v. Moss argument in Johnson, specifically. That additionally, in Leighton R, they only addressed the stop. And here we have certainly more than the stop. I would still maintain that in totality of the circumstances, the stop was the evidence at the hearing established that the police only had the ability to trigger their common law right to inquiry. But here we have more than just the stop. We also have the pat frisk. And certainly Leighton R does not go into the search of the vehicle because they claimed that it was consented to, and that was not an issue. So certainly, even in view of in Leighton R, if this court believes that the stop was justified as a level 3 under the totality of the circumstances, the pat frisk certainly was not, because there was no any additional evidentiary observations by the police or actions by Mr. Robinson that would lead the police to believe that he was armed and dangerous, which is required for the pat frisk.
And do you want to address the Bruin issue or just rely on your brief?
I will rely on my brief with regard to the Bruin issue.
Okay. Thank you very much.
Good morning, Your Honors. I'm Marty McCarthy with People. I was remiss not to do an additional case citation to Leighton R. It was sitting on my desk, but so were lots of other things, so I apologize for that. I think Leighton R actually controls this case. The facts of this case in Leighton R are...
Well, counsel, that was a traffic stop.
Correct. But,
and counsel says, well, this is a pat frisk issue here.
but the question they were addressing was reasonable suspicion. So the question becomes, did they have reasonable suspicion to believe a crime was about to be committed, was going to be committed? That's the standard to stop a vehicle under reasonable suspicion. And they found that an anonymous tip can do that in Leighton R. So, like, to me, this changes the landscape from Moore, where Moore held it required predictive behavior, and it didn't necessarily invest the police with the ability to conduct a reasonable suspicion stop
Yes.
based on anonymous.
So your position is that that's a new test for reasonable suspicion, right?
Absolutely, absolutely.
And so,
And one of the, when you look at how they used Neverett, which was a Supreme Court decision, they invested significance in Neverett, the language regarding the use of the 911 system, the 911 system's ability to record calls and place the location, geolocation for the call. And in Leighton R, that happened. So the officers knew the geolocation of the caller in Leighton R because he used the 911 system. The police here, same thing. They knew where the caller was calling from. They knew he was calling from Hague Street, based on the geolocation of him using the 911 system. And the language in Leighton R says that use of that system significantly increases reliability.
Because one of the things they said in Navarrete, as I recall, that was a California case, and they pointed to the California statute which allowed the people to prosecute a misreport using the 911 system, I think maybe as a felony. We have something very similar here as well in New York.
Absolutely. So here, the only difference that I detect between Leighton R and this case was in Leighton R. There had been some information that initially had been conveyed that was erroneous, whereas here, nothing that had been conveyed had been erroneous. And there was a shorter time gap in this case than there was in Leighton R. So the fact that call is happening contemporaneously with the stop.
that's part of the totality of the circumstance.
Absolutely.
I mean, it was within a minute here.
Yeah, within a minute. So they were still getting details. In fact, if you watch the video, I'm sure you watched the video, you can hear that over what's being relayed over the air and on the CAD report is that the gun's in his pocket. I think it was his right front pocket or his left front pocket. And the police officers, they hadn't really started the pat first. They had sort of did this to his jacket. When that information came out, she went right to the pocket and there was the gun. So even under Moore, that would have been a description of the concealed conduct. So if there are no other questions, I will also rest on my brief for the Bruin argument.
We're all set, Mr. McCarthy.
Thank you.
Next case is number 62, People v. Alexander. Ms. McGee is by video. You're muted, Ms. McGee. Good morning. I believe you're unmuted now. Can you hear me okay?
I can, Your Honor. Thank you. My apologies.
Not a problem at all. Well, we can hear you just fine. You're solo today. So what would you like to tell us as part of your argument?
I would like to just briefly address two claims, Your Honor. First off, the claim that Denman requires a new trial because the underlying allegation of the victim committing perjury also drives the defendant's arguments that the evidence was legally insufficient and the verdict was against the weight of the evidence. First of all, this Denman claim was not preserved by a timely motion for mistrial or objection. It rests on a flawed characterization of both the record and the statute. Moreover, the defense was fully aware of the material witness order and elected not to make use of that by seeking to impeach the victim's testimony that she was indeed a willing witness. They did not seek to make use of that of cross-examination. And insofar as it may be suggesting that the people's material witness application was deficient, I'd simply note that I know of no case law that holds a defendant has standing to challenge a material witness adjudication. Lastly, the record does not show why the hospital records were not introduced into evidence.
Yes, I was wondering. I was wondering about that. That's what I was going to ask you next. Because there is medical records and they weren't introduced as part of this case.
I don't know the explanation for that, Your Honor, but what the record does show is that the medical records were turned over as early as October of 2023, months before the trial, and that's reflected in the certificates of compliance dating back to October 3rd, 2023, and again at record page 197, where the people affirm in response to the defense challenge to the validity of the COC and statement of readiness that they turned over the medical records on October 2nd of 2023. And this attorney is certainly, defendant's attorney is certainly a very seasoned, ardent, zealous advocate. And if those medical records actually did not bear out the victim's testimony that she had suffered broken ribs, I'm confident that he would have impeached her with that. And he did not.
Ms.
So
Ms. McGee, I have a few questions for you, and they all arise out of what I'll refer to as the car wash incident,
yes,
right? And that has to do with counts 13 to 17, as I understand it.
yes,
And I believe you've conceded that we should dismiss count 17. Do I have that correct?
yes, because there was not physical injury apart from, it rests on the strangulation, loss of consciousness.
So, but you cite to a case right in that same paragraph where you concede a case of ours called People versus Pohl, POHL. And you
Yes.
say that loss of consciousness is sufficient there. So if it's sufficient as physical injury in one case, because physical injury, the definition to my knowledge doesn't change. So if it's sufficient under Pohl, according to your brief, why is it not sufficient here? And therefore, why did you concede?
I thought that it was more, the counts were concurrent, and I thought that other physical injury is captured as the Pohl cohort, but that her testimony regarding the lack of consciousness was certainly convincing evidence of strangulation.
But don't all of those charges, I may be missing something, doesn't 14, 15, and 17 don't they all require a physical injury?
Yes.
So if you concede 17 based on the absence of physical injury for the exact same event, don't all three fail?
No, I think you could conclude that I erred by conceding that there was no physical injury.
Well, as you know, we have to independently evaluate whether or not your concession was appropriate. So that's what I'm really driving at is, are you now arguing that on reflection, that loss of consciousness for the purpose of counts 14, 15, and 17 is a sufficient physical injury under Pohl, even though Pohl was an aggravated criminal contempt? I think you seem to limit it that way in your brief. But that's what I'm struggling with. And I'm not trying to put you on the spot, but I have to kind of get it sorted out. That is, it seems to me 14, 15, and 17 stand or fall together. Do you agree with that?
Yes.
And are you withdrawing your concession, or you want to think about it a little bit and give a post-argument submission?
I will withdraw the concession. I think that the way the statute was written was to make sure that it was understood that loss of consciousness was a form of physical injury that should give rise to the charge. This was an amendment of the statute that was felt necessary because of the preceding case law. And that's what I focus on.
Counsel, I've got a question. All right,
Yes.
so there's a difference between serious physical injury that's necessary in 17 and 15 as opposed to physical or serious physical that's necessary in count 14. There's a difference, isn't there? Because in number 14, they give us the option of physical injury, not just serious physical injury, correct? And there's a different definition of what you need for physical injury as opposed to serious physical. So
Absolutely.
my question, count 14 would be a little different than 15 and 17.
That's absolutely correct, Your Honor. And I'm sorry, I don't have the indictment in front of me to make
Right.
on the spot reference to.
Okay, well, thank
I'm
you.
sorry, I didn't mean.
No, I'm done.
Did you allege in any place in the indictment serious physical injury? I don't see it, but I may have missed it.
No. Well, as I said, I don't have the indictment up in front of me. My recollection is
okay.
that
I
the people
stand corrected.
charged,
Okay, I'll look at that. It was something that I just was a little confused on, and I think I need to get it straightened out in my head. So thank
I
you.
understand that, Your Honor, and I apologize for contributing to any confusion.
No, I got to get it sorted out. Thank you.
Thank you.
You're all set?
Yes.
Great.
Thank
Have
you
a good
for your
day.
attention.
Thank you. Let's see, we're going to go down to number 67, People versus Burris. I think Ms. Field is by video. Very good. Ms. Field, can you hear me okay? As you can see, you're still muted. I know you're trying to fix it. That looks like you're unmuted. Ms. Field, can you hear me okay?
Yes, I can. Can you hear me, Your Honor?
We certainly can. We're going to allow counsel to start with his argument now.
Terrific. Thank you.
May it please the court, Jonathan Garvin for Mr. Burris. If there are no questions by this panel, I'll be relying on my brief.
I have one.
Yes.
Is this the case where you have to be careful what you wish for? Because your client's out, right? And maybe as close to serving as peer as post-release supervision too, I think.
That's true, Your Honor, but if you read the record, he was very adamant. He repeatedly denied the charges and
That's a little bit unfair. He didn't deny the charges. My reading of it is that he denied certain facts that were being alleged as part of the charges until finally they got down to a set of facts that actually fit the crime. And I know you wanted to just wave on the.
I can respond to that, Your Honor,
Sure.
because I do believe he was denying the charges. It's my reading of the colloquy where he was asked repeatedly, did you possess a loaded weapon on 2 separate dates? And he repeatedly said, no, he did not. But my reading of that is because they asked him about the wrong date. They finally got to the right date and then he admitted it. I mean, this was torturous, without a doubt, but eventually, my reading of this is he eventually admitted to the elements of the crime that he pled guilty to. Just to push back a little bit, count 1 was a particular date. So if it's the wrong date, that's the date he was charged with a particular date. He denied that he possessed a loaded weapon on that date. So I don't think that's a wrong date. That's just him denying the charges. And then they switched to another date. Again, did you possess a weapon outside your home or business? He again denied the charges. And I think the prosecutor was mixing up. He was, they were trying to, they were going all over the place. They were trying to figure out count 1, count 3, inside, outside. And the court did eventually get to a date. And then under a different theory that had been talking about, he went to whether he was inside, and they talked about a video, and that's how they keyed in. But by that point, there was no opportunity. This is where I think the court was wrong to deny the motion is at that point, we all know that PLL 265 it's been called one of the most complex and cumbersome section of the penal law. But by that point, after all the bouncing around, it is not clear that he understood that the exception to the exception when you're possession inside a house would not apply. And he, contrary to what the court said, he didn't have an ample opportunity to discuss that with his counsel, and the counsel wouldn't have even brought it up beforehand because they were going on possession outside the home. So there wasn't an opportunity to say, well, if you go inside the home, the exception.
Counselor, he eventually had pled guilty to attempted possession, which was right.
He did. Yes, that's correct.
Which in some ways clarified some of that confusion at the outset, didn't it? The court's proposal to take the charge to attempted?
Okay, so once he denied count one, the prosecutor did offer to offer attempted, but he still tried to ask the question again, was it out, it was like inside or outside? And it was a court that, realized that there was some evidence of a video or pictures inside. And but the confusion that was not corrected, and that a layperson would not know that that the in-home exception would not apply in that case, whether it's attempted or not attempted. Defendant's statements at the argument on his motion were clear that he didn't understand that, and the court said, well, you had ample opportunity to speak of that with your attorney. And at the time, during the colloquy where everything was going back and forth, he did not have an opportunity. And he said he would, if he had understood the acceptance of the exception, that he would not have pled guilty. And that's why, even though so much time has passed, we're still here.
Counselor, do you think that the standard is solely whether there's evidence on the record? I think it's fraud, innocence, or mistake. Is that the standard that we should apply? It must fit within one of those three categories in order for us to reverse. You cite the cases where we use the words confusion.
Yeah, Hector and
Does confusion have to amount to fraud, innocence, or mistake, or is it a separate grounds? So that's why it was a double question there. That is,
okay.
Does it have to fit within one of those three categories, or is there some other category that you're arguing?
Well, we're arguing under the umbrella of it's got to be knowing, intelligent, and voluntary. And I'm raising the issue that this was not knowing and intelligent, and under the subcategory of I'm not saying there's fraud. I'm saying
Did he claim innocence?
In his pro se motion, he did claim innocence.
And did he claim mistake?
He claimed he didn't. Mistake versus not understanding. I'm saying that falls under mistake.
Okay, thank you.
Okay. If there are no further questions, I rely on the brief.
Great.
Thank you.
Ms. Field.
May it please the court, Bridget Field on behalf of the people. I agree with Judge Bannister. This was a difficult plea, but I do believe it was sufficient. Defendant was very clear in his denial of the counts relating to February of 2018, and he wasn't afraid to speak up about that. He also clearly admitted to the possession of a gun on December 22nd. There was confusion or some additional questions regarding where that possession was. He did admit that he possessed the gun outside the home on that date. The additional questions related to where the gun was loaded. And ultimately, the defendant admitted to the existence of a video wherein he was unloading the gun, apparently in his house. But again, this charge was a reduced charge of attempted criminal possession of a weapon in the second degree. So I believe that the trial court was appropriate in denying the motion to withdraw the plea in this case.
Okay. Anything further, Ms. Field?
I would rest on my brief unless the court has any further questions.
Hearing no questions, we're all set. Thank you very much.
Thank you. Have a good day.
Next is number 68, People versus Walsh. And as I understand it, both counsel are remote. We have both counsel. Ms. Waldman, can you hear me okay?
Yes, can you hear me?
Yes, we can. You're a little light on the volume, but that could be just my hearing. And Mr. Bassett, can you hear us okay, sir?
Yes, Your Honor.
And we can hear you too as well. Ms. Waldman, all set. Go ahead.
Good morning, Your Honors. May it please the court, Kara Waldman representing Mr. Walsh. Addressing weight, I know that the jury requested to watch the video footage multiple times was deadlocked, and the court had to give an Allen charge before the jury ultimately convicted Mr. Walsh. Mr. Walsh is requesting that the court dismiss the indictment. Bobby and Shauna were interested witnesses and had a motive to lie. Bobby was facing her own felony charges after intentionally running Mr. Walsh over with her Jeep twice. She was protecting Robert, who is potentially facing a weapons possession charge based on shell casings found at the intersection where his car was positioned in the video prior to Bobby running over Mr. Walsh. I want to emphasize that the video footage does not support Bobby's and Shauna's description of events. On the video, Mr. Walsh is not crouching. He is not seen with a gun in his hand. He never raises his arm. There are no muzzle flashes and no gun was ever recovered. I did not do a good job addressing this in my brief, but in People's Exhibit number 1, in the file entitled Zoom Short Version, there is another individual who can be seen by a utility pole to the middle left of the screen immediately after Bobby runs Mr. Walsh over and backs out. This puts another individual at the scene while everything is happening. Mr. Walsh was also denied the effective assistance of counsel when counsel failed to request a missing witness charge because the entire case hinged on the credibility of Bobby and Shauna. Although there were casings from 2 different guns that were found at the scene, as I explained with respect to weight, there was nothing in the video footage that definitively showed that Mr. Walsh was firing a gun. Contrary to the people's contention, Robert would have offered non-cumulative evidence about material issues, including, among other things, setting the narrative about the fight that occurred earlier in the day, why he was sitting outside of the house on Spring Street and for how long. He had a different vantage point of the shooter, and he also could have testified about the shell casings found at the intersection. The people's cases are distinguishable from the instant one. In Ferguson, the 3rd Department said that the testimony would be cumulative because the passenger of the vehicle, quote, observed defendants driving from the same vehicle and vantage point. That is not the case here. Regarding availability, the prosecutor's statement that Robert was unavailable because he was on a fishing boat in Alaska for months at a time was conclusory and speculative, which is exactly what the Court of Appeals deemed insufficient in Savanon. Binion, Marine, and Lamont are also distinguishable because in those cases, defense counsel actually requested the charge and the court was able to engage in the analysis required. Here, defense counsel, although given the opportunity, never requested the charge. This one error was enough under Turner to deprive Mr. Walsh of a fair trial. If the court disagrees, however, counsel failed to object to all but one instance of prosecutorial misconduct. In light of the preservation error, Mr. Walsh requests that the court address the instances of prosecutorial misconduct outlined in his brief in the interest of justice. I'm not going to go into each instance of misconduct, but want to point out that the people's entire theory of the case centered on Bobby as the martyr and heroic mother saving her son's life by running Mr. Walsh over when he was shooting at Robert. If the theme of a mother protecting her son from death is not a theme that appeals to the sympathy of a jury, I honestly don't know what would qualify. The credibility of Bobby and Shauna was central to the people's case, and the prosecutor's comments vouching for their credibility, especially Bobby's, severely prejudiced Mr. Walsh. Regarding the one preserved issue, the burden shifting, these statements came at the end of the prosecutor's summation.
That's part of the problem, isn't it, Ms. Walden? There's only one that was objected to, correct?
Correct, but as I explained, I believe that it was ineffective for counsel not to object to the other instances of prosecutorial misconduct. And I think this is especially important in a case where the evidence was not overwhelming. And again, like I said, the jury was deadlocked. The court had to give an Allen charge before the jury convicted Mr. Walsh. And then finally, his sentence was unduly harsh and excessive. Robert and Bobby were never charged or even really investigated, but the video clearly shows that Bobby ran Mr. Walsh over, and she admitted during the trial that she did it intentionally. Mr. Walsh requests that the court reduce the sentence to 7 years in the interests of justice. Bobby's actions towards him led to life-changing injuries to him. These life-altering injuries in 7 years is enough punishment under the unique circumstances of this case. Unless the panel has any other questions, I rest.
I think we're all set, Counselor. Thank you.
Thank you.
For the prosecution.
Yes, good morning, Your Honors. Well, let me ask you, are there any of these issues raised by appellant you'd like me to specifically address?
I'm sorry, I couldn't hear you. Forgive me.
Are any of the issues raised by appellant that you wish me to specifically address?
No, we'll trust your judgment. How's that?
Okay, well, let's just start with the weight of the evidence as appellant did. It's our position that this is a credibility case. The driver of the vehicle that ran over the defendant said that she saw him with a gun. Why else would she run him over, of course? Her testimony was consistent with her passenger, Miss Pitcher, who also said this person had a gun. There's no dispute that defendant is the person they ran over. There's also no dispute that—
Counselor, but it wasn't consistent with the video that was showing what was happening.
Well, I would disagree, Your Honor. The video showed an individual emerge from between these houses and appear to run in the direction of Mr. Jennings' fleeing vehicle and take a firing stance. And that is when the Jeep driven by Miss Janik plowed into him. The quality of the video is not good enough to make out a weapon. I don't disagree on that. And you can't see muzzle flashes either. But we had testimony from an expert that you don't always see muzzle flashes during daylight in this kind of situation. But the video, by and large, aligned with Miss Janik's testimony that this person came out, started running towards her son's vehicle, and started firing. Now, that was also consistent with the shell casings found on the sidewalk. That was also consistent with a projectile found in Mr. Jennings' trunk of his vehicle. And it's our position that the video and the forensic evidence aligned with this witness testimony, and the jury was perfectly situated to assess whether Ms. Janik's testimony was credible, and they found it was. And this court should not disturb that finding. That's our position. As to the effective assistance of counsel or defendant's claim to the opposite, it's our position that missing witness instruction was not warranted in this case. It was not requested, and it wouldn't have been successful if it had been requested. Mr. Jennings, again, was driving away from the scene of this shooting. This is just a criminal possession of a loaded weapon case. We didn't have to prove, the elements of intentional murder or anything. We just had to prove that this was a person, the defendant, who possessed a loaded firearm outside of his home or business. Janik was in the best position to offer testimony in support of that theory. She saw him and she ran him over. And there was her testimony, her passenger's testimony, the video and ballistics evidence. And in comparison, Mr. Jennings was driving away. It's not clear that he would have had any non-cumulative material testimony to offer. And we would also argue that he was unavailable in that he was on a fishing boat in Alaska. I'm not sure if it was a deadliest catch boat, but he was unavailable because, as you know from maybe watching that show or others, these guys go out there, they're out of contact for days and weeks at a time on the other side of the world. And under the circumstances, he was not available. So,
but do we really know that he was in Alaska on a fishing boat? What established that?
Well, first, Your Honor, the prosecutor made that representation to the court. Second, Ms. Janik testified to that effect at trial. This is her son. She said he's on a commercial fishing boat in Alaska. She's out of contact with him, and she doesn't know when she can see him next, that he's gone for months at a time. But because the defense counsel didn't raise this missing witness idea. It was not specifically developed, further. But I would submit, just based on those facts, that the people made a sufficient showing that he was unavailable under the circumstances. And the remainder of the comments complained of by appellant, I don't think rise to the level of sufficiently egregious or pervasive to really prejudice him. Mostly, we're talking about comments that were, fair response to a defense counsel's comments or a fair characterization of the evidence. I mean, the people's theory here is that Miss Janik ran over the defendant when she saw him with a gun shooting at her son. I mean, that is a heroic action. I mean, I don't think it's inaccurate to characterize it in that way. That was certainly something that was fair comment. And if there's no further questions, we would just rest on our papers.
We're all set, Counselor. Thank you very much.
Thank you.
Moving next to number 69, People versus Honeycutt. The appellant is by video. Ms. McMahon, can you hear me okay?
Yes, I can. Can you hear me?
You're a little light on the volume, but otherwise you're all set to go. We can hear you. Go right ahead.
Okay, great. Good morning. May it please the court, Allison McMahon on behalf of the appellant, Amarius Honeycutt. Gonna keep the weight argument relatively brief. The credible evidence in this case establishes that a gun went off while Mr. Honeycutt, Mr. Hinkle, and Ms. Rivera were in a vehicle, but there's no evidence to establish where the gun came from, how the gun went off while they were in the vehicle. And that's not enough to convict Mr. Honeycutt of possessing a weapon.
What about afterwards when in the video someone's seen picking up the firearm?
I think the video is extremely, it's unclear. You really, no matter how many times you watch it or zoom, you can't tell what the object is. And even making an assumption that it looks to be a weapon, we still don't know if that gun is operable or that gun is loaded, if it is that in the video that falls out of the car with him, because we have no idea what happened in the vehicle. And so
We know a gun went off. We know a gun went off in the vehicle, don't we?
yes, but we don't know where that gun came from, how it went off. And that's really the core of the weight issue here, is that what happened in the vehicle is unknown, really. And then second, the video itself, I don't believe was sufficiently authenticated. And I don't think it should have been admitted into evidence. There is also no chain of custody established whatsoever for the video. We don't know where it came from, how it was recorded, how it was stored, any of that information. And then I briefly would address the trial penalty issue that I talked about at the end. And while disparity between a plea offer and a sentence after trial isn't dispositive, I think here there is some facts that are spoken about and the way it's done that indicate it was a punishment for exercising his right to trial. There's nothing new really at trial. He was acquitted of the 2 top charges and only convicted of 1 after, and there was an additional 4 years sentenced. Whether, the witness feared him was not appropriate, because there's nothing to show that that's why her demeanor was as it was. And also, I don't believe that his actions can be called cavalier. If you fall out of a moving vehicle and jog away, I think that's just kind of what a reasonable person does. I think it would have been odd if someone just stood there and casually walked away. And so I think that was not appropriate to base on enhancing the sentence in that way. There are no further questions. I'll rest on my papers.
We're all set, Counselor. Thank you.
May it please the court, Jerry Marti for the people. I'm going to address the last point first, as to the trial penalty, because it comes up often. Sometimes there's going to be plea negotiations and then ultimately you get a higher sentence at trial. As the Court of Appeals in Pena stated, and this court stated in Taplin, the fact that there's a higher sentence doesn't indicate a trial penalty. It indicates only that there's a negotiation process. Without more, it's not enough to show a trial penalty. Here they attached a publication issued by criminal defense attorneys across the state. I would submit that that's not enough to show that there was a trial penalty in this case. Going to the weight of the evidence, the verdict was consistent with the weight of the evidence. The crux of the defense argument was you can't believe those two witnesses because there were some things that they testified to that hurt their credibility. That may be the case, but that doesn't render their testimony unworthy of belief, that it was impossible of belief. Here, there are two witnesses in a car involving a gun that went off in close range. This is different from the case in Leon that was cited by the defendant, in which a police officer had testified that he saw a gun underneath someone's clothing as they drove by.
Quick question on the weight for me, Mr. Marty, is I looked at the photos and looked at the videos, et cetera. In the photo, there's a photo of the shooting victim. And it appears there's a mark on the back of his neck. And I forget what the testimony was at trial. Was that an entry wound or an exit wound?
I don't recall that particular fact, Your Honor, but I can state that the investigation found a bullet hole in the vehicle, which goes to the criminal possession count.
I'm sorry to interrupt, but in the roof of the front of the vehicle, right?
Correct.
So at least the inference is that it entered the back of the victim's neck.
There was a tussle. So during that tussle, the victim may have been turned around as they were fighting over a purse. That was their testimony, or a bag, which leads me to the last point. I'll rest on my arguments in terms of the authenticity of the video, but I want to point something out in terms of harmless error. It's an 11-second video. It actually helps the defendant if you think about it. The defendant was facing 2 counts of attempted robbery. That video shows him falling out with a black object, which was consistent with the witness testimony as to a black gun. There was nothing in the video showing a purse or a bag. So on the one hand, they're saying that it wasn't enough, that video shouldn't have come in. But on the other hand, it helped them to get an acquittal on 2 counts. Unless there's any other questions, I'll rest on my brief.
We're all set.
Thank you, Your Honor.
Moving next to number 70, People versus Van Doren.
Good morning, Your Honor. May it please the court. James Hobbs on behalf of Mr. Van Doren. This is a one-issue appeal focusing on the appropriateness of the conduct in front of the grand jury. I believe we've established that the issue survives the guilty plea, and the people concede that portions of the argument at least survive the guilty plea and the waiver of appeal, and therefore are properly presented for review and are preserved. The main one I raised 3 separate.
Real quick, just don't lose your train of thought.
Yep.
I just want to get this out there for your consideration. Does it have to, with respect to the error, have to be of a constitutional jurisdictional dimension under Hansen?
Yes, I believe it does.
Okay.
Yeah.
And that's what you're going to tell us about, because if it doesn't fit that category,
yes,
it doesn't survive.
That's correct.
Okay.
That's correct. I believe what we have here is essentially equivalent to a case of prosecutorial misconduct, which affects due process right in the misrepresentation of this forensic evidence to the grand jury. The fentanyl evidence, the people knew that he had been administered 200 micrograms of fentanyl immediately after this accident. They knew that the blood draw came after this. And then they presented this evidence to the grand jury as though it was affirmative evidence of his intoxication by fentanyl.
Counselor,
Yes.
was the blood test the primary evidence of intoxication?
Yes, it was. There was, I mean, there's circumstantial evidence in the fact that there was an accident in broad daylight, right, where he falls asleep at the wheel. There's also a sample taken out of his pants, a baggie, which only had a presumptive test for fentanyl that was entered in the grand jury, but that was later shown to be unreliable. The lab test showed it to be false. And so, and even before that, the presumptive test is not a significant amount. The blood draw is a much more significant and much more reliable evidence of intoxication by fentanyl. There are other intoxicants shown in the blood draw as well. Marijuana or cannabinoids, the derivatives of marijuana use. But I believe the blood draw is the vast piece
Counselor,
yeah.
I mean, you know, when you read your brief, you sort of pass over the marijuana is also present in that blood test. And you focus on the fact that the prosecutor presented to the grand jury that it was positive for fentanyl.
Yeah.
On the other hand, if the prosecutor just ignored it, that's what you're saying. The prosecutor should have just ignored the presence of fentanyl, but then at the same time, when Dr. Nemeth is addressing the grand jury, he should still testify about the marijuana that was detected in the blood sample. That's your point. That's the only way the prosecutor could have walked this grand jury presentation safely, is to eliminate any reference to the fentanyl.
I believe that there was a second line. You know, if the expert could have established that there was evidence of a greater amount of fentanyl in the blood test than would be consistent with the medical administration afterwards.
Because you would agree that the marijuana would have supported the grand jury's finding as to the impairment.
Correct. The problem is that there's about, half of the counts or more, I don't remember the exact number off the top of my head, but there's numerous counts that involve fentanyl. So he's facing a great deal of jeopardy based on these allegations of fentanyl or combined impact of fentanyl and other things. It puts a vastly different case.
This would be right. Your argument, in my mind, would be a different argument if the marijuana wasn't also present.
Correct. Yes, it would be. I think it would be a knockout of
a much stronger case. Yeah.
Yes. Right.
Along those lines.
Yes.
And I'm getting back to my first question. If the law is, as I understand it to be, that the people are not required to introduce all exculpatory evidence, right? I think that's the law in New York, right? If that's true, and your complaint here is that they failed to do exactly that, that is, some exculpatory evidence was not presented. How does that rise to a constitutional jurisdictional dimension? Where's the constitutional violation? Where's the jurisdictional issue?
Yeah,
that's what I'm really stuck on. I'm not sure this survives, because it seems pretty well clear that it's an evidentiary issue that the people are not required to do exactly what you suggest they should do, and that you say is a constitutional violation.
Well, I disagree with what people are saying and how you're characterizing it as exculpatory evidence, and that's how the lower court treated it, as a case of the district attorney failing to present some exculpatory evidence. I view this as a affirmative misrepresentation of forensic evidence. If you imagine a case where there isn't this other the evidence of cannabis, and this is the only thing they've got fentanyl in the blood draw, and they know that was administered prior to after the accident. If the prosecutor had just presented that blood draw and no evidence of the fact that it was given, even though they knew that it came in afterwards, I think that's affirmatively misleading. It's not just a failure.
That was my point, but that's a different case than what we have here, right? What you just presented, that hypothetical, is a different case than what we have here.
It's different with respect to the charges in the indictment. that involve marijuana, but it's not different.
Because in
with
order
respect
to strike the indictment, we'd have to show that the prosecutor literally misled the grand jurors. And
Mhm.
in your case, if the prosecutor knew for a fact that there was no fentanyl in the defendant's system at the time of the crash,
Mhm.
but nevertheless presented it to the grand jury so that they could only draw one conclusion, that there was fentanyl,
Mhm.
that would be misleading.
Yes. And I think, I mean,
That's what we have to find here for you to.
I don't know if, I mean, you're suggesting that he had to know that there was no fentanyl in the system. I mean, he may have had, the prosecutor says at various points in the transcript that, even after being presented with the fact that, the fentanyl was entered into his blood after the fact, and the presumptive test came out negative when it went to the lab later. There's points where he's saying, I still believe he had fentanyl in his system. But it's just sort of this like gut feeling, it seems like. And I think the prosecutor needs to have something more than that gut feeling.
Are you saying that the prosecutor also has to know that the only fentanyl in his system was what was administered to him by the paramedic?
Yeah. Oh, well, or that the expert could suggest that the levels found in the blood were consistent with more than 200 micrograms or
perfect
older. If they can't, I think that they shouldn't be presenting that as evidence of fentanyl and asking the grand jury to vote charges that are based on fentanyl.
Affirmative, and I'm sorry I talked over you again, Mr. Hobbs, but to have an affirmative misrepresentation, as you say, along the lines of Justice Del Conte, not only would they have to know that there was no there, that they would have to know that he didn't have any before the accident or before the accident. And I don't see the record in this case supporting that argument, very honestly. And if I'm wrong, please tell me.
Well, I mean, we're talking about the levels of knowledge. I think there's a the amount of good faith belief that they need to have. I think that this presentation stretched beyond a good faith belief, particularly after, knowing that the blood draw was tainted and knowing that the lab test came back. There's one point that I wanted to take that I might have addressed in a reply. There's a claim that I rely on the fact that there's only hearsay connecting the blood draw to the defendant. I understand that a claim of hearsay would sort of go to sufficiency of the evidence rather than a constitutional error or jurisdictional defect. That point about there being only hearsay is combined with the fact that the prosecutor later misstated the fact that they had heard evidence about a court-ordered blood draw. And that statement by the prosecutor was argued about in court, specifically for numerous pages on the May 25th appearance. It was first noticed by the court, but the defense counsel launched into a long argument about why this was a problem. So it's certainly preserved. And the argument was that, that it was directly tied to the lack of, to this tainted blood, because they didn't want to ask the police witness about whether or not, why Mr. Van Doren didn't consent to the blood draw, because that question would have drawn out his statements that, no, I don't want to do it. Implicitly saying they gave me a lot of narcotics, which was the reason he gave for not wanting to consent to it. So, the prosecutor said it was a slip, and I guess it's, a misstatement, that he didn't mean to mislead the grand jury about that. I think we can evaluate that it was, but I think that combines with the misrepresentation of this blood draw to sort of taint the process. There are no further questions. Brief.
We're all set, Counselor. Thank you. Mr. McCarthy?
Thank you, Your Honor. Marty McCarthy to the people. Justice Del Conte, I think you kind of hit the issue right on the head, which is the fact that this isn't just a case about fentanyl, it's a case also about marijuana. And Justice Curran, you pointed out, the law is very clear. Lancaster, the other case I can't remember right now, and penal or CPL 19050 sub 6 provides the defendant a mechanism to address this very issue he's now raising.
Was a notice for 19050 notice served on the defense, letting them know it was going to be a grand jury proceeding so that they could offer their own evidence?
I'm not sure if that's actually in the record, but he was arrested. And I can tell you typically that's what would happen. To the extent it's not in this record, if the court would request it, I could certainly provide it after. But yeah, since it was pending in local court, as a matter of course, we always serve a 19050 notice. So he did have the ability to present this evidence, fentanyl evidence. And had he presented this fentanyl evidence, maybe this case would have turned out differently for him with grand jury, but maybe not. But again, what we don't know is something that you pointed out, Justice Curran. We don't know whether the fentanyl that was administered at the scene of the accident by the EMTs was the only fentanyl he had. And that requires a scientific analysis, which is just not in this record. So maybe that would have gone further to demonstrate the defendant's claims in this case, but it's absent. So absent that, you can't say that the prosecutor violated his duty of good faith fair dealing in this case. And my position on the other two issues is that one was unpreserved, and both of which can't be reviewed by this court based on the waiver of appeal and the guilty plea. Are there no other questions? Okay.
Well said, sir. Thank you.
Have a good day.
Next is number 71, People v. Richardson.
Morning, Your Honors. May it please the court, Ryan Bergman on behalf of the appellant, Mr. Joshua Richardson. Your Honor, this is a single issue case about the constitutionality of 265.033 being read in concert with 265.027. 265.033 details the situation in which a charge for criminal possession of a weapon in the second degree can be maintained in instances in which one of two provisions are met, namely in this case subsection 7, as that was the charge of the indictment, that Mr. Richardson possessed an assault weapon in the home. Our argument is that based on the historical analysis test that was developed by the Supreme Court in the Bruin case, the aspect of the definition of an assault weapon and the barring of having that inside of one's home doesn't stand up to the historical scrutiny of gun regulation in the United States.
Haven't we said something, Counselor, to the effect in a number of cases that Bruin didn't entirely invalidate our licensing system and our weapons possessions provisions?
So, Your Honor, I believe the court's referring to the decision in Thomas that's from the Court of Appeals in 2013 has come.
There's three cases that I have written down in front of me from our court, Brinson, Davis, and Mancuso.
So Davis, I believe, is the on-trial Davis case that I believe is going up in front of the Court of Appeals sometime this calendar year. With some certain questions, which is why I still think that the issues to the constitutionality, considering the Court of Appeals in their decisions that have been referenced by lower courts, basically sidestep that issue, focusing purely on the licensing aspect and the fact that the constitutionality in that case wasn't a preserved issue. Here it is Bruin was decided during in between the plea and the sentencing, which is why the attorney below requested that the plea be withdrawn. Our belief is that it is still it's still a nebulous area of the law as far as how it potentially can be looked at from our approach. We do believe that the historical aspect of gun regulation through Heller, allowing the use of weapons in the home and possession there.
Counselor, that line of cases dealt with an individual's ability to be licensed to carry a concealed weapon. The proper cause. The question in front of the court was is the proper cause requirement constitutional or not? Correct?
Are we talking about the Bruin case?
The Bruin case.
So that's one aspect of it, yes.
Right, but this is a little different in the sense that this would be an assault weapon that really, even under the licensing statutes, the proper cause requirement, which was the only issue in front of Bruin, doesn't apply to assault weapons, does it?
Well, so Your Honor, I think what
If this was a handgun, it'd be a different case, maybe.
if it were a handgun, I think that there are greater parallels, but I think
You'd have a better case if this was a handgun than an assault, right?
that very well may be.
Yeah.
But I do think that the parallels themselves are very similar. There is no regulation against long gun ownership. Obviously, there isn't the same sort of kind of structure as there is for handgun ownership outside of.
There's different long guns, not a hunting rifle or a shotgun, right? But we're talking about an assault weapon here.
That's correct, but our argument is that the Bruin case, which lays out the test for basically challenges to the Second Amendment.
Your position is you have a constitutional right to have an assault weapon in your.
Our argument is that the rule that was set forth in the Bruin decision says that our belief is that to make sure that the restrictions on these type of weapons are legal, they must pass this historical analysis scrutiny test, right? And I would submit that in the course of this country, right, the amount of gun regulation that's happened with concerning assault weapons is limited to basically the Brady Bill in '94. And I mean, there are 43 other states in the United States that have these type of weapons, right? There was a Second Circuit case, the Cuomo case, which is in my reply brief, in which the court basically said there that these weapons are not unusual in any way, shape, or form. That is normally how people use to apply the assault, but they're dangerous and unusual in nature. Obviously, I think we can all agree that any gun, regardless, has some element of danger to it. But they have said that it isn't unusual to the aspect in which they can kind of get to the purposes of using that as a reason for banning. And our argument here is that the historical aspect test of Bruin applies to the wide gamut of regulation because there needs to be some sort of kind of historical analog, I think, to make sure that it doesn't fall down at that level.
We'll take a close look at your brief as we already have.
Yes, if there's no other questions, I'll rely on the briefs then.
Right.
Thank you.
Thank you.
Morning, Your Honor. Brad Osler for the people. I think this court's previous decisions on this point sort of foreclose any further discussion or a different result here. And I think that's kind of the end of the discussion. I could go further if there's any questions, but I can rely on my papers.
We'll look at the brief as we have. Well, thank you very much.
You're not going to drive home with that.
Not allowed to.
All right. 72 is settled. 73 is up next. This is a matter of Jeffrey Harper versus Snow. Mr. Steinberg is remote. The respondent has submitted and the AOC is here. Mr. Steinberg, good morning, sir. Can you hear me okay?
I can hear you, but I'm still seeing technical problems here.
Just so you know, we can see you just
Oh, yeah,
fine.
okay, yes.
And we can hear you just fine. You're all set, sir. Go right ahead.
Yeah, okay, thank you. This is
Before you even start, Mr. Steinberg, don't we have an issue here as far as what you are appealing from is a mere decision, and there is no appeal from a decision?
Aware of that. It is a decision that ends with, this constitutes the order of the court. And yeah, I came into this after the time for any notices of appeal had passed. It's within the court's discretionary power to deem this to be taken from the later order, which really simply sets out the same terms that were in the memorandum decision. But it does seem to me that if the court says this constitutes the order of the court, we shouldn't throw people out of the appellate division because they took the trial court at its word.
Wait, I believe in here, he actually says that the AFC shall draft and submit a proposed order consistent with this decision.
True, it
It's
says
pretty
both.
clear that this is a decision, not an order, and that he is waiting for the AFC to draft and submit the order.
It is, yes, it says that, but it also says that this is the order of the court. And it's very confusing, which is sort of par for the course in this case.
Mr. Steinberg, the later order that you point to in the record all refers to it as a memorandum decision.
Yes.
So the order itself does, but I get your point. With respect to that later order, there's no evidence there that it was filed or served, correct?
No. When I got the papers from Wayne County Clerk, it was not in those papers.
Okay, so theoretically, if it's not been filed or served, your time hasn't even started to run yet. That would be one argument, correct?
True.
Is there anything else you'd like to add? We've all read your brief. We'll look at it again very closely. Anything further?
Yes, Your Honor. I mean, this is a case where the very peculiar procedural development of it, in particular, Ms. Salisbury's concession to the violation petition on the condition that nothing in the violation petition would be considered by the court, left the court making a decision without any evidence.
And what standing do you have to assert that problem?
What standing do we have to assert that problem?
The problem being that your allegation in your brief, as I understand it, is you want us to relieve the mother from her admission to the violation, but you represent the father. I'm having trouble with the relief that you're seeking. In addition to the other issues, Mr. Steinberg, respectfully, I'm having trouble finding out how that's your issue.
The father did join in that request.
Yeah, but it's not his admission to make or to withdraw. In any event, that's just something that's on my mind, so that you know it's part of the thought process, at least that I've got going on here.
The thought problem that I have is that I can't appeal what the court did. Pretty much the only thing that constitutes evidence in the memorandum decision, which we say is in order, is that the judge found that the child's ability to even want to see his father has been tainted by the words and actions of the mother. But what the court did was reduce the contact between my client and his child. We have no way of appealing that because there's no evidence to understand why the court made the decision. In fact, the court was all along saying, this is what I'm going to decide. And the court decided what he said he was going to decide. But there needs to be some evidentiary basis for that decision. And the way this proceeding went on, that evidence never got in.
Would you characterize this, and I forget if you did this in your brief, as a sua sponte order?
Which portion of it?
The order you've on appeal, would you say that because you weren't given a hearing and no notice that was proper, that it was effectively a sua sponte order that could be subject to a motion to vacate? Again, I don't know if that's true, but is that part of your thought process?
It is not, Your Honor. We don't see it as a sua sponte order. Both parties were there. Both parties wanted the court to make a decision. But there was nothing that, there was an attempt. Mr. Snow's trial attorney tried to bring in evidence, and the court said, no, this is done. And on top of that, of course, not only was the court determined to make the decision it made, it was apparently determined not to make certain decisions, in particular, when visitation would begin and what its terms were. And he was told, you have to make that decision. You can't delegate that to a therapist. And Judge Williams said, I'm going to do what the therapist tells me to do.
At a minimum, Mr. Steinberg, you've certainly have demonstrated on this appeal that this is not the ordinary course that we see these cases come up in. I see your point in that regard.
I've always loved procedure. It bores a lot of people, but if you don't follow the rules, you end up with messes like this one. And our real appeal is this was wrong from the beginning. It should go back and be done properly.
Okay, thank you very much, Mr. Steinberg. The respondent, as you know, has submitted. We'll hear from Mr. Muldoon as the AFC.
May it please the court, Gary Muldoon, for the child. As Justice Smith has pointed out, this appeal is taken from a memorandum decision. I believe Mr. Steinberg, in one of his briefs, noted that he had received the corrected document, the order, which I found by contacting the Wayne County Clerk's office. And if it was not entered, and or if it was not, it was entered, it was signed and entered, but if it was not served upon the other parties, then the opportunity to perfect an appeal based on that still would exist, theoretically, even to this time. So I believe that the appeal was taken from the wrong document. Now, Mr. Steinberg is saying that this court has discretion on which, it's not limited to the one, it could consider the other. But in his brief, he seems to take strong exception to my pointing this out and saying, no, this is the right one that I have appealed from. So he's chosen a certain path and should not be allowed to say, well, it was the wrong path, but let's consider the other one. So they're appealing from the wrong document. The second thing that is unusual in this case, and there's many unusual
things that are unusual in this case.
Yes, is that this is a case in which this is the 11th court proceeding that has been brought by one party or the other, yet he is challenging the judge's decision to not vacate the 10th decision, the J petition. And I don't believe that is appropriate. That is not an issue before the court. The case was the K petition, matter of Jeffrey Harper versus blah, 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 blah. And that is to criticize the AFC's position in the J petition, I think is wrong. As an AFC, I certainly take the position that an AFC has the right to take a position in this, and the father's attorney takes strong exception to the right of the trial AFC to take a position that the parents have taken. Well, just because the parents flip-flop, the child does not have to flip-flop.
What's the child doing?
The child is 10 years old, is in 5th grade, living with the mother, is attending school in Sodas. The child has multiple issues, has a full-time aide with him throughout the school day. There's only 2 children in the entire school that have that kind of assistance. The child has ADHD, PTSD. The child has certainly has significant problems. I spoke with the child last night, and he repeated what he said to me before, which is that given the history in this case, he does not wish to have this case go on further. He does not wish to have contact with his father. This is a child. The child has not done well with these court proceedings. If the court has no further questions, I will submit.
We're all set, sir. Thank you.
Thank you.
Moving next to number 74. There are 3 attorneys on this matter and all are remote.
Can you hear me, Your Honor?
I saw the third person come up, so it looks like we're all together here. I think we have Mr. Kaminska. You can hear me okay, Mr. Kaminska?
I can, thank you.
Excellent. We can hear you as well. Mr. Pavarono, you're next. Can you hear me okay, sir?
Loud and clear, Your Honor.
And we can hear you as well as Ms. Jerkis. Can you hear me okay?
Yes, I can.
Then we're all set to go. So, Mr. Kaminska, you're first up, sir. You represent Nyack, correct?
That is correct, Your Honor.
Go right ahead.
Respectfully, as the counsel for the appellant, we're asking this court to reverse the decision of the Supreme Court. Our arguments here are pretty straightforward, as you can tell from the briefs. As to next level, we believe the Supreme Court erred in granting next level summary judgment and denying our cross motion, as it failed to give meaning to all the terms of the operative indemnity agreement. As the court is well aware, and the parties do not dispute, the right to indemnity depends upon the specific language of the contract. Here, the contract language, like that in the Scarrett case we've cited, as well as other cases in our briefs, calls for indemnity for claims actually or allegedly arising out of or relating to next level's work. That's the agreement at 1107 of the record. Clearly,
Mr. Kaminsky, that argument I saw in your brief, and you made that there too. Let me ask you on that argument, just generally speaking, for you to succeed vis-a-vis next level, must you establish that next level was the general contractor?
I do not.
Why not?
Because all that I need to establish is that the contract was in effect. There's no issue about that. There's not a question that it was signed by next level, and that there are allegations that fit within the purview. The difference between this case and all the cases cited in opposition is that the language, the specific language here, is that it doesn't actually have to arise out of their work. That next level does not need to be negligent. All that has to happen, and we see it in Scarrett and in Collado and the other cases there, is that the allegation arose that plaintiff made allegations about the work being done at the New York Athletic Club. That gave rise to the indemnity obligation. It's a broad indemnity obligation, Your Honor.
Let me ask you this, Mr. Kaminsky, and I'm not sure this is apples to apples, but this is the best example I could come up with quickly, is let's assume that next level was an electrical subcontract, and they had the same language in their contract. Would they also be on the hook to your client for indemnification?
If the plaintiff asserted facts in a complaint, a bill of particulars, in a motion asserting liability arising out of their work, yes, because of the allegedly language. You know, the Court of Appeals recently, just last month, decided a case, DeBrino. And in DeBrino, the clauses there don't include this broad language of the allegedly, so that, and it was very particular as to the definition of work. We don't have any of that stuff here. So while the analysis of the Court of Appeals went through in DeBrino is the same analysis you go here, you have to look at the specific language. Here, the language is broad, clearly implying a duty to defend and indemnify. And it's funny, because as you read through the whole indemnity paragraph, it even notes internally that this is a broad document, because should a contractor hire a subcontractor, which in this case, my understanding is that actually Next Level did. They hired electricians and demolition people. They would have to have an indemnity agreement, as the document says, as broad as this.
Mr. Kaminsky, isn't the argument on the other side, and I'd like you to address it, isn't there argument that in this situation for this contractor, who does not have to be a general according to argument, but for this contractor Next Level, in order for them to be on the hook, so to speak, to your client or otherwise, that they have to have some role or authority to supervise the work of the plaintiff involved here? Isn't that a requirement of the case law vis-a-vis indemnification, that Next Level have some authority, if not actual authority, to supervise the work of the plaintiff?
No, I don't believe so. And I think the Scarrett case stands for that proposition right off the bat, that liability is not required. Indemnification is not required. At common law, Your Honor, a party can be indemnified even for their own negligence. This case, because there's no negligence on behalf of the New York Athletic Club, General Obligations Law 5-322.1 doesn't come into play. That statute's in derogation of the common law, which would prohibit being indemnified for one's own negligence. But at common law, you can be indemnified even for your own negligence. It's not a requirement that the indemnitor have liability. So much of the brief that goes to the tort liability of next level to the plaintiff is simply inapplicable.
Would you take us next to the Anderson situation?
I would love to, Your Honor. As to Anderson, it's rather a simple argument. The Supreme Court, in our view, engaged in issue determination when it granted summary judgment. The court stated that nothing in the record showed that the indemnity agreement was retroactive, but that was really not accurate. Sal LaFerlita for NIAC provided evidence that the indemnity contract was sent with the scope of work. That's at 1090.
Mr. Kaminsky, here's my question on this case as to Anderson. Section 11 of the Workers' Compensation Law, as I understand it, says the written contract of indemnity must be entered into prior to the accident or occurrence. You agree this document was not signed until after the date of the accident, correct?
I agree that it was not executed by Anderson until after the accident, but I disagree that it was not entered into before, because Mr. Sal, I'm going to call him Sal because it will keep me from stumbling over his last name constantly, because Sal testified that he had provided evidence that he provided it then, and that he followed up with it.
What I'm drilling down on, Mr. Kaminsky, for my benefit, and not so much, I mean, just I'm curious about this as to the phraseology of the case law. We have cases, the other appellate divisions have cases that say, yeah, you can apply it retroactively, which is what you're seeking us to do, as I understand it. If you meet two conditions, that the contract was entered into as of a date prior to the accident, and second, that the parties had an intention to apply it retroactively. I'm focused on the first element, that it was entered into as of a date prior to the accident. I see nothing in this contract that says as of this date or a date of contract that precedes the accident. We have a case that came out, I think, within the last year called Freeze, F-R-E-A-S. And there, the date of the contract was before the accident, but the parties clearly executed it afterwards. We said there was a question of fact about the intent for retroactivity, but there, at least, there was a date as of prior to the accident. The way I see the weakness in your case, respectfully, is you don't have that here. The only date you have is afterwards. There's nothing that's as of, correct?
I understand your argument, and certainly would I love to have a heading at the very beginning of that document that says entered into as of November 1st. Yes, I would love to have that, but that doesn't mean there's not a way around that. The clear language of the indemnity agreement says that it applies to all work done by Anderson, okay? Combining that language with the testimony or the evidence provided by Sal, the fact that they believed it was sent to them and agreed to at the time of the scope of work, that Mr. Anderson cannot refute that because he doesn't know when he got it. When you combine that with the fact that Mr. Anderson actually executed it, which why would he have executed it at all if he had no agreement for that?
Mr. Kaminsky, just this is a procedural matter. That argument I recognize is in your brief. You quoted the contract. That is favorable to you. I understand that, no question. But it just procedurally for my benefit, because we set up our MEMS this way, our memoranda. Would you agree that in this situation, Anderson carried its burden to demonstrate as a matter of law that it did not enter into the contract prior to the accident by having the testimony of Mr. Anderson that I was given it after the accident, or at least that's when I was asked to sign it. I signed it after the accident, and I specifically refused the request to backdate it. Do you think on that testimony that at a minimum, Anderson carried its burden such that it burden shifts to you to raise a triable question of fact as to the two prongs
trying to
of the
think if my
test.
answer is that I'm raising an issue of fact by by Sal's testimony, or and in fact, I would say no, and here's why I would say no, is that Mr. Anderson testified he didn't know when he got it, and he can't say that I didn't agree to it when he didn't know when he received that document. And then when you combine the fact that Sal is telling him he received it when he received the scope of work because it was all agreed to at the time, I think it's an issue of fact. I don't think they met their prima facie case. And even if they did, an issue of fact was raised. And I think, again, you know, my argument here is that why would he sign it anyway?
Okay. Mr. Kaminsky, anything further? I think we have your argument. We're certainly familiar with your brief. We'll keep looking at it. Anything further from you, sir?
No, sir, I think you have my argument. We will rest on our brief, and I respectfully thank the court for its time.
By the way, I commend all three of you for avoiding the trip to our beautiful city here today. We do have a little extra precipitation in the air, so your wisdom is shown here so far. Now I'll switch to Mr. Poveromo, who has Anderson, as I understand it.
That's correct, Your Honor. May it please the court. Good morning, Your Honors. Richard Poveromo on behalf of Anderson Courts, the third-party defendant respondent. I think the court has identified the key issues on my piece here. And we think Judge Martocci got it right.
Counselor, I'm going to jump off of Justice Curran's questions here. The language in the service agreement that states that the agreement's in effect for any and all work done by the contractor appears at the bottom of that first page. The language as to the responsibility to indemnify is at the top of the contract. It says arising out of any of the work. What's the purpose of that sentence at the bottom of the contract if it doesn't mean all work from the beginning that the work was commenced?
Well, I think the answer is that demonstrates at best ambiguity, right? Because that's under a heading that says subrogation. There's no temporal aspect to that language. I mean, it's any and all work, so it's modifying or describing the type of work, not a time frame. And the courts, as Justice,
but we're not confused about what work, because this contract's a broad contract. It arises out of at least at the first portion of the contract. It covers all of the work that the contractor is going to do here. Why do we need this language at the end of the agreement if it doesn't relate to the timing of the performance?
Why do we? Well, I guess I'm a little bit unclear about the question.
Jim, what's the purpose of that? What's the purpose of that language in your mind if it doesn't relate to if it doesn't control the timing of the performances in terms of the operation of this agreement?
The purpose is, again, I think that's a kind of a mystifying question because it's not specific with regard to that. And we have to look at, as courts do appropriately, indemnity agreements look critically. They need to be specifically defining the scope. I know where you're going with it, Judge. Why it doesn't modify a temporal time frame is because we have an entry that says date, and it's clear that this was dated after the accident. And the courts have even let's deal with that broad language there. The courts have said there must be express indication for a retroactive contract to apply that the parties intended it to be so, and there has to be language expressly stating it. So I would caution the court to use that language to somehow read into it modifying a temporal time frame. It only speaks to work. It doesn't, that we can't then take the leap and say work before the date that this was executed, which is clearly after the accident. Does that make sense?
Well, yeah, I mean, I suspect that was going to be your answer, but any work could be interpreted as any work done at any time. That's essentially what we have to.
But it doesn't say any work at any time, right?
Right.
It says any and all work, right? From December 6th forward. And we can at least agree that that in and of itself is ambiguous.
And Counselor, just glomming on Justice Del Conte's question, that is the language of the contract seems to be what gets NIAC in the game here in that regard, if they are. But what I'm persuaded by, or at least influenced by, one of the first cases on this line of cases that allows retroactivity is called Stabile, Stabile, and then there's a case called Burke, both from different appellate divisions. But in Stabile, at least the court quoted the words "as of." That is, you need to show that it was as of, and it puts it within quotes. I don't know what significance exactly that has, but when we lawyers talk about something being as of, usually that means in the contract, as Mr. Kaminsky mentioned, he would love to have that phrase "as of" a date pre-accident. So my question to you ultimately is, do we have a case, or do you know of a case where a court has specifically said the contract, in order to be retroactive, must say something to the effect of "as of a pre-accident date"? I looked, I couldn't find it. Have you?
The closest case, and I would direct the court to take a look at this case. It's not cited in my brief, but it's citing them papers at the record 1217 below. It's Jardine. It's the Jardine case, 138 AD 3rd 927. And it's factually on point. And in that case, the court says, and I can quote it here if you'd like. There's no indication the indemnification, which was dated after the accident, was expressly or intended to apply retroactively. It has to have that language. And then it went so far as to say that any testimony, which I have an issue with if you want me to go there later, that it was intended to be a part of the contract executed prior to the accident is extrinsic and should not be considered. And in that case, they totally dismissed the contractual indemnification claim against a third party defendant, which is exactly what Judge Martocci did here. If it was intended to apply to any work beforehand, why is the only evidence that NIAC was so insistent that we backdate it? And that's getting to the extrinsic evidence. And what I will concede is the courts are reluctant to look at extrinsic evidence, but I think every step of the way, if we look to the agreement, it has to start December 6th after the accident. If we look at any extrinsic evidence, the only evidence is that they were asking us to backdate it because they had an accident on their hands and they didn't contemplate this agreement until after it happened. And for those reasons, we believe Judge Martocci correctly looked at the record and found in favor of Anderson courts.
Great. Okay. Counselor, thank you very much.
Thank you.
We'll turn now to counsel for next level, Ms. Cherkis.
Yes, thank you, Your Honor. I think timing here is actually a very important issue. And as you know from my papers, Next Level had completed their work under the contract, and they were no longer at the New York Athletic Club. They had removed all their equipment. They were gone. And the indemnity agreement that we are talking about has specific language that Mr. Kaminsky ignores, which is before you even get to arising out of or allege, it starts with while performing work. So that indemnification agreement with regard to Next Level, it takes us, and the judge was absolutely correct about it, takes us out of having an indemnity obligation here because we were not performing work at that time. And from Your Honor's example before about, what about an electrical? Well, according to Mr. Kaminsky, working in there would be owing them indemnification, even if it had nothing to do with their own performing work. That, we were no longer performing work. So it takes us out of that. in addition, I know we referenced about the general contractor situation. Not one document calls us a general contractor. In fact, the documents, if you do look at our whatever documents of ours, which had to do, say, for the indemnity agreement, it gave the same one over, to the third party defendant. We are both defined as contractors. Neither one of us are called a general contractor. And even in the bid documents that I pointed out in my brief, there is one place where the word general contractor is in there, and it specifically excludes us because anything that we are going to buy or purchase or anything is supposed to be without general contractor the percentage you get because you're the general contractor getting the other people to do it. So we're not that either. The testimonies of everyone is, we didn't direct third-party defendants. We both agree on that. They didn't see us. We were not a general contractor. But, all that said, we were finished with our work. I do want to say one thing. I did notice on the reply brief of Mr. Kaminska, I noticed that in the record, we have their work orders, and I made reference to the one where there had been redaction. This wasn't our document. This was a document of third-party defendant. But I noticed there was one version of it that he made reference to that did not have these redactions and made reference, and this has to do with notes taken by someone employed by the third-party defendant, notes going through about trying to get other stuff done at a later time. And apparently at some point, they're trying to get in touch with Next Level to see if they can do some other work. This was not the work that was part of this contract. And it's just a flow of inquiring about that there were invoice issues, things like that. And their payment schedules were actually different between the two companies. Apparently, the arrangements, I guess, with Anderson and New York Athletic, they had a long-term relationship, and they did something a different way. But all that said, I know I went into much in my brief, was while performing work, and we were not. The one other thing I know that the judge also got rid of that procurement, which was clearly justified sua sponte, because as I put in my brief, that had been something that had been in the third, when we were named into third party, and it wasn't even in so while they didn't change the caption, we were then only a defendant, and it wasn't asserted by New York Athletic at that juncture. And in addition, our client did testify about that they had procured the insurance. They got what they had to do for the work that they did. This was not part of it. This was that indemnity agreement is beyond putting us.
Hey, Counselor, you're asking us to affirm. Do I have that correct?
Yes, I am. On every level. I'll rest on my brief.
Great. Thank you very much, lawyers, for your arguments.
Thank you, Your Honor.
Yeah.
75 is submitted. Next is number 76, Caputo versus Holt. Mr. Caputo's here, Mr. Benz is here, I'm told, and Mr. Sarando is is remote. Mr. Caputo? No problem at all. You can just grab the podium, and I just want to test the microphone. Bear with me just for a second.
Sure.
Mr. Sarando, good morning, sir. Can you hear me okay?
Yes, I can, Your Honor. Can you hear and see me?
We can do both, and you represent the Holt defendants, so to speak, right?
Yes.
Okay, and I think we're all set to go, Mr. Caputo. And just so you know, and you probably do, given your experience below, the panel has read the briefs. We're familiar with the important parts of the record. So we're prepared to focus on your arguments. So right ahead.
Okay, may it please the court, James R. Caputo, plaintiff appellant in this case. I appreciate you having read the case. It's kind of a unique, somewhat complicated case, but I think it's pretty straightforward. We have a group of people who acted against an in-place, in-force mechanics lien, and sold a house against the lien and against a court order. I think it's pretty clear as to the details and the facts of how the lien was falsely represented by defendant Cheney to the other parties, going completely against the order by Judge Valeriani. And I believe that they violated multiple statutes in doing so. Rather than re-argue my entire case, obviously I'm here to try to overturn the lower court's summary judgment decision, which I believe was in error. Not only was it premature, but it was certainly not based on the material evidence or the facts in the case. In addition to the fact that the court ignored the fact that there was a pending nunc-pro-tunc motion on this case to extend the mechanics lien based on the Schillian case. This case is interestingly almost identical to the Schillian case, which enables that nunc-pro-tunc extension to the mechanics lien because it was erroneously extended without motion. And I believe the statute has, in the county clerk's office, has responded to this case in the fact that there was kind of a setup within the county clerk's office for these motions to be allowed to be extended without, these liens to be extended without motion. But that being said, I believe I've made a compelling argument in my briefs as to why the lower court's decision was in error. I believe I still have the right to, through this court, receive that extension on the lien, even though it's long after the fact, since this case is still open. I believe I've proved my position on the new homeowners having inherited the lien. The language is very clear in their mortgage papers and everything else. I also believe that Mr. Cheney did owe me a responsibility. He says I have no fiduciary relationship with him, but I think I made a compelling argument that he has an indirect or an informal fiduciary relationship to me because, like all the parties in that transaction, me being the lien holder, I was relying on them all to just play by the rules.
But he didn't represent you, did he?
Yeah, but I'm relying on him to play by the rules with the lien instrument that I had an interest in. So he convinced the other parties that Judge Valeriani's decision was moot. It was a standing order that had ruled on the name issue, and he falsely represented that to the other parties, fraudulently, on the misidentification versus a misdescription issue. And Judge Valeriani made that very clear. And so he owed me his legal duty to follow the law.
He represents a different party.
Yeah, but the different parties, what he represented, my lien was inextricably involved with their dealings. And so I now bore the fiduciary benefit of all those parties following the rules and following the law and saying, we can't sell this house, there's a lien on it. And they said, you know what? What can he do to us if we just sell the lien? Sell the house against the lien. And that's what they did. They leveraged the fact that they didn't think I would have any ability to touch them legally and denied me 6 months of work. $25,000 is not pocket change. I was relying on that money for a transition to another city to start my business, and it has hurt me incredibly. And then having to fight 4 years now to be paid with every step of the way. It's like justice is moving further away. So I think that this case is very clear. I think the court has an opportunity to send a strong message to those who think that they can just spit on the lien law, like was done here, to spit on a standing court order. Judge Valeriani made it very clear there was only 2 instances that this property could be sold. And they said, the heck with it. We're just going to do it and stick it to this guy. And I would defer the rest of my time. I'd like to respond to what the defense has to say.
Mr. Caputo, just so you know.
Oh, I do not? Oh, I'm sorry.
I forgot to mention that at the beginning. So you should know that unless you read our rules.
I would love to answer any questions that you might have.
I think we're all set, Mr. Caputo. We certainly give us a comprehensive brief and record. We'll take a look at it as we already have. Okay. Next is Mr. Benz.
Good morning, Your Honors. Please report, we represent the Cheney Law Firm and Mr. Cheney.
As Justice Ogden indicated, your primary argument is that you never represented Mr. Caputo, you had no fiduciary duty to him, so therefore and I don't want to cut you off here, but it seems to me that's your primary argument, is that we should affirm on that basis.
Yes, Your Honor. There were three claims asserted against Cheney Law Firm and Mr. Cheney. Was the breach of fiduciary duty, a contempt of court claim of sorts, and then a fraud claim. And with respect to the breach of fiduciary duty argument, it's exactly as Judge Ogden indicated. We've never represented Mr. Caputo. We represented Robert Houle and his company in connection with a real estate transaction. Mr. Caputo seems to essentially argue that anyone involved in something that might potentially lead to litigation, your fiduciary duty to everyone involved. So that you could have a weird situation where essentially litigation arises, and under his theory, then I somehow owe a fiduciary duty to, quote, get it right to the opposing side, which I don't believe is what the law says, and I don't believe is appropriate. In this situation, we never represented Mr. Caputo. As such, there was no fiduciary obligation ever created. That cause of action fails.
And you've cited case law to that effect in your brief. Mr. Caputo says I should have a broader duty. We'll take a look at that. What else?
Thank you. With respect to the idea of a contempt of court argument, there's a reference to this Judge Valeriani decision in order. In that situation, our office did not represent Mr. Houle. He proceeded pro se. We were not a party. We did not submit any papers. We were never even served with a copy of this order.
Is there a cause of action for contempt under New York law?
Not really. I mean, it's raised, but I don't necessarily. I wanted to raise it, and there is no, I would say, a private cause of action for contempt of court. Anyways, it would be something for the court to enforce. So that brings really to the one remaining argument, the idea of this fraud. And I guess our main position would be, a cause of action for fraud requires a misrepresentation of a material fact made to, in this case, the plaintiff, that the plaintiff relied upon that representation to his detriment. And the question is, what misrepresentation do we make to the plaintiff if he's saying we represented to third parties about some kind of fact? So in this situation, I don't believe that he has a cause of action for fraud. At best, in this situation, you could, I suppose, theoretically argue that the buyers could assert a claim for fraud if somehow the lien was found to be valid, as opposed to what we believe it to be. But even then, I think, given the nature of how real estate transactions happen, I don't even think that type of cause of action could be supported, because you have a bank attorney, a buyer.
But it has to be a misrepresentation of fact as opposed to your legal opinion, number one.
Exactly.
And then there'd have to be reasonable reliance upon somebody else as a lawyer to give you that opinion.
Exactly.
And that's what we're looking at, among other things. But what else?
And just so again, I believe that it's not a claim that Mr. Caputo could ever have asserted against us in the first instance. This was a claim that at best, if this lien was found to exist and then encumbered the property that the buyers bought, that theoretically the buyers could perhaps try to assert, but they didn't. So it's not Mr. Caputo's claim to make. As a result, I think the court recognized it, that the only way something like this a claim could have existed was if we essentially induced everyone on the other side of the buyer, the bank's attorney, everyone into this belief that this lien was valid and could force this deal down their throats, essentially. And so for those reasons, we believe the lower court got it right with respect to dismissal of the claims against Cheney Law Firm and Mr. Cheney. Thank you. Unless there are other questions, I would rest in my papers.
Hearing none, you're all set, sir.
Thank you.
So I don't see Mr. Sarando on the screen at the moment. We'll just give him a second, or give our folks a second to see if he's still around.
Your Honor, Mr. Sarando has dropped off the call. He might be having network problems. We can't do anything about it on our end.
Yeah. What we'll do is, if he does come back, let me know after the next argument and just ask him if he wants to be heard, that he should hang on at that point. But we're going to go to the next argument, and after that one, if he wants to be heard, we'll take it up at that time. Just let me know, please. What's that?
Make sure they have it still.
Yeah, so Mr. Caputo, Mr. Benz, if you don't mind going back to the audience, just so we're respectful to Mr. Sarando, to listen to him as well if need be. Okay?
Thank you.
So don't let me forget about you. Just stand up back there and let me know, and I'll see you back there, okay? Number 77, City of North Tonawanda versus Penn Power et al. Justice Del Conte is disqualified. And we have Mr. Garvey here and Mr. Lennon remote.
No. We hope.
There he is. Mr. Lennon, good morning, sir. Can you hear me okay?
Good morning, Your Honor. Yes, I can. Thank you.
We can hear you as well. We're going to let Mr. Garvey proceed. Go right ahead, sir.
Good morning, Your Honors. May it please the court. Tyler Garvey on behalf of Daimler Truck North America. For the sake of efficiency, I'll jump right into my first main argument, which is the breach of warranty claim. DTNA moved to dismiss plaintiff's breach of warranty claim as untimely under the statute of limitations, and the lower court found properly, I think, that we met that initial burden.
And they agreed that you met that initial burden, correct?
Yes, I think the factors underlying that are pretty much uncontested still. The main and I think only basis upon which plaintiff opposed that branch of our argument was that the warranty claim could satisfy the future performance exception of UCC 2-725. And that's the basis on which the court denied the motion solely, this branch of the motion. And I think that's erroneous for a couple very simple reasons. Plaintiff has asserted only a breach of implied warranty claim against DTNA. There's nothing in there that remotely resembles a breach of express warranty claim, and the future performance exception is only even theoretically applicable to an express warranty claim. That's kind of an intuitive principle, I think, but we've cited several cases to that effect. But essentially, an implied warranty can't explicitly guarantee anything because it's implied. So I think that
Is there any allegations in I think it's the amended complaint?
Yes.
That there was an express warranty or an assurance of future performance?
Correct, there are not. The entire cause of action is cited in our papers. The warranty described is identified as a creature of common law and statutory warranty only. There's no allegation that DTNA made any sort of representation to plaintiff in any way, oral or written. There's no allegation that plaintiff relied on such a representation. There's really just, it's just an implied warranty claim. It's not an express warranty claim to short circuit it. And so that the court, of course, erred in determining that this implied warranty claim could ever satisfy the future performance exception. And that's really the framework or the field of play that was before the lower court when we brought this appeal. There's a bit of a wrinkle that has since developed, which is plaintiff's belated assertion of a toll in its.
And if we were to address that, you'd probably say that that was unfair to your client because you didn't get a chance to address it below and counter it in whatever way you may have or may not have been able to. And if we address it, that may then not even be available to go to the Court of Appeals. There's a case recently called Sabine that seems to say in order to be preserved for the Court of Appeals to hear it, it has to be preserved before the Supreme Court in this instance. And that wasn't done. So not only would we have to, Mr. Serrano, sir, you should be on mute. So not only would you be treated with what you perceive to be unfairness here, you wouldn't be able to take it to the Court of Appeals. So that's sort of what we got to look at when we look at the toll.
I agree with you on all those points, Your Honor. I would just
I'm not saying I agree with you. I just want to let you know that we understand your argument in that regard.
Okay. Well, I would also just add that it is substantively prejudicial because the lower court really quite explicitly defined plaintiff's warranty claim in its order as a warranty claim that would be, quote, dead in the water if there was not evidence of a future performance guarantee uncovered. And so it really was very explicit.
Hi, John Randall, I'm on again.
Now, Mr. Serrano, sir, just stay on mute. We'll be back to you in a few minutes.
It was very explicitly tied to this future performance exception, and we were directed to conduct discovery on this warranty claim conceived in this way. And that's what we did. And now discovery is complete. We have a trial date. And I think essentially if this court were to consider the toll, it would substantively and functionally broaden the warranty claim in a way that now we just can't explore because discovery is complete.
And you also have a motion based on the two negligence causes of action or tort causes of action, correct?
That's correct, Your Honor.
And your argument there, if I understand it correctly, was that those are precluded by the economic loss doctrine because if I read the complaint correctly, it's only alleging economic loss, property damage.
That's exactly correct. And I think with respect to the economic loss doctrine, the issue really comes down to damages. The damages are alleged are property damage to the truck itself, which is the exact same product as defined in the complaint that DTNA allegedly negligently manufactured and defectively designed. And the truck is the only item to which plaintiff claims property damage. The only other damages plaintiff claims are loss of use of the truck and the cost of rentals. These are just classic economic loss doctrine type damages. And I think the economic loss doctrine analysis really should end there. And that's where it should have ended for the lower court. But unfortunately, pardon me, it did not. And the court seized upon the allegation that the fire occurred through that the damage occurred through an accidental fire as something that could potentially distinguish and bring this out of economic loss doctrine territory. And there are several cases that we've cited, Boker, Ofsowitz, and the SS East River decisions, among others, that demonstrate that is simply, there just is not an exception for cataclysmic occurrences, abrupt events, accidental type damages to the economic loss doctrine. Specifically, there is no exception for an accidental fire that occurs in a vehicle and causes it to burn. And that's the Ofsowitz case. And if you have questions about the lower court's treatment of the Flexivit and Hodgson cases and why those are distinguishable, I think that's pretty extensively briefed. But
I think we have it in your brief, is right.
Yes, we do. It's extensively briefed. And
I'm not hearing any questions from the panel. I think we're all set. We'll switch to Mr. Lennon.
Excellent. Thank you very much.
Thank you, Your Honor. Almost good morning still. J. Michael Lennon on behalf of the appellant, the city of North Tonawanda. With respect to the statute of limitations portion of the motion to dismiss, first, we believe that the trial court did get it right in the sense that it's at that early pleading stage of the case, the court gave us an opportunity to conduct discovery. The judge in the oral part of the decision, which is included in the transcript, made clear that he was very cautious when it came to motions to dismiss to make sure parties had ample opportunity and were given the benefit of the inference. With respect to the toll issue, I think it's important to understand that while appellate courts generally are hesitant to allow new arguments, they're not barred, and there are circumstances where they will be considered. And in their reply brief, because that was their opportunity to respond to the argument that I raised in my respondent's brief, the appellants cite multiple cases from this court. And as an example, the Michael M. case. They only cite the first part of this court's standard for whether or not it'll consider a new argument. The general rule that an appellate court should not and will not consider different theories or new questions. But there's a second part of that, an if, that has to be considered as well. If proof might have been offered to refute or overcome them. And when you look at that, what we're dealing with here is a pure question of law on this toll issue. They don't contest that the COVID toll exists. They don't contest the cases that we cited in our brief where this court applied that very toll to a statute of limitations. So it's a pure question of law which could not have been avoided had I raised it below. Certainly, as counsel, I regret that that issue wasn't raised below, but I don't think that when you're dealing with a question of law like this, that ultimately it precludes consideration now. There's no factual proof that they could have offered. We agree the date of accrual, September 27th of 2019, the date of delivery. We agree statute of limitations, unless the exception that we argued below applies, the statute of limitations is 4 years under the UCC. So but as a matter of law, that toll was available. We were not aware of it at the time we made the argument, even though it was available. They don't challenge our calculation. So we respectfully submit that the court can and should consider the tolling argument. And when the court considers it, it's clear that the toll, when applied, makes our amended summons and complaint timely. With respect to, yes.
Counsel,
yes, Ron.
so let's just say, assuming you get by the toll argument, okay, and we apply it, et cetera, counsel raises another issue which seems to end the inquiry, doesn't he?
And I'm sorry, Your Honor.
And
what
that
is-
being the economic loss, you know, the pure, that you're seeking economic loss purely, and that's not permitted.
Thank you, Your Honor. Well, the statute of limitations argument relates solely to the breach of warranty cause of action.
Right.
The economic loss doctrine argument relates to the 2 tort causes of action. So there's 3 total causes of action. So we disagree that the economic loss doctrine bars our tort claims, but even if this court finds that it does, the statute of limitations could save our 3rd and remaining cause of action for breach of warranty. And so,
Mr. Leonard, do you wish to address the economic loss issue and the 2 tort causes of action?
very briefly, all I will say, and we set this forth in our brief, the trial court again was looking at the procedural posture of the case and said at the pleading stage, it took the Fourth Department's rule in Hodgson at face value, where the court said that when you're looking at the economic loss doctrine, you should consider the nature of the defect, the injury, the manner in which the injury occurred, and the damages sought. And the court stepped back and said, you know what? I think that there should be some additional discovery, not prejudicial to your motion for summary judgment in the future. And I can tell you, having sat through all the discovery, Mr. Garvey and Daimler Truck were very thorough in the discovery that they conducted. And just last Friday, they filed their motion for summary judgment on these very same issues. So I don't believe that there's any prejudice to Daimler Truck should the trial court's decision be affirmed. And I would respectfully request that that's what this court do.
Very good. Thank you very much, Counselor. We're all set. We're going to recall the previous case, number 76. Mr. Caputo, Mr. Benz, why don't you come back up? I think we've been able to get Mr. Serrano back online here.
Okay.
Mr. Serrano, all's well that ends well, sir. We're all set. The other folks have argued. Is there anything you'd like to tell the court that, in addition to what's in your brief?
Very briefly, Your Honor, and thank you for the opportunity for me to get over my bout with technology. The lien, we represent the buyers, the mortgage company, and the abstract company. Unfortunately, the lien for the appellant, unfortunately, the lien was invalid because he filed it against Mr. Howell and not the owner of the property, Howell Sales Consulting, Inc. The property was subsequently sold.
Mr. Serrano, can you hear me okay?
Yes.
I'm going to just interrupt you real quick. I thought one of your arguments was that the lien wasn't properly renewed and therefore it seemingly expired under law, irrespective of whether or not we accept the idea that there's a, what is it, misdescription as opposed to misidentification. I probably got that confused.
Okay.
But isn't that one of your, I thought one of your arguments that really the lien didn't exist as of, a certain date in January?
January 21st of 2023. And I think when you look at the Cook case, an opinion by Judge Keel, where the Fourth Department previously held that the lien lapsed by operation of law because the lien was not extended by a court order, and the lien holders in that case purported to extend their liens by simply filing a notice of extension, which was done in this case. So,
But isn't Mr. Caputo's response to that, Mr. Serrano, isn't his response for the plaintiff that, wait a second, I filed a motion to have it extended nunc pro tunc, and there's a case from the Supreme Court or whatever that supports that. Is that before us? I mean, what do we do with that request?
that request should have been before the trial court. And on page 51 and 52, the appellant indicates that he was told approximately a month before the sale that the sale was going to be happening within a month of this property, and he never did anything at that time to I think it was May 22nd. He never did anything at that time to protect his lien. So if the lien was filed against the proper owner, then I think he would have a stronger position in regard to that Nassau County case, I believe, which should have been raised to the trial court. And we'll rely on our brief unless the court has any questions. And I appreciate the callback after I don't know what happened, but something happened.
It's all fine, Mr. Serrano. No problem at
Thank
all.
you.
We're going to move to the next case. Thank you very much.
Thank you.
Mr. Caputo, thank you.
Thank you.
Moving next to number 78, we have Minor Realty and Property Management versus Lockhart. And the respondent has submitted, and we have Mr. Morosco here, correct?
Yes, Your Honors. Good morning and thank you. May it please the court.
Good afternoon.
Good. Well, it's good afternoon now. Yes. So I really only have two main points I'd like to hit on briefly before the court. The first being that a non-owner, in order to maintain a proceeding under Article 7 of the RPAPL, a non-owner, an agent, property manager really must show that they have some kind of right or interest in that real property in order to.
Counsel, that in this case,
Yes.
that party is the party that leased property.
Well, Your Honor, that's the party that signed a lease agreement.
I understand, but that's the only party that engaged your client in any type of a contract.
Correct, Your Honor.
So is it your position that the management company had no authority to transfer possession to your client?
Yes, Your Honor, it is.
So they had no authority or power to transfer possession to your client.
Well, I think more specifically, it's that they didn't show that they had the authority or the right to transfer that property. I think that there's two aspects to a lease agreement that need to exist for an estate and land to be granted from one party to another. One is the privity of contract. You have to have the document that you sign, but you also have to have the authority and the grant, the ability to transfer
They
that.
established that through the testimony of the person, McCormick, the office manager,
Your Honor,
testified about the fee owner giving his interest.
Well, I don't believe that testimony is sufficient to establish that the petitioner in that case had the kind of exclusive control over property that is requisite under cases that this court has decided, such as
that was the entity that was collecting the rent, was taking care of any problems in the place, that's the tenant was communicating with this person. I don't see how you can say that there was no.
So, Your Honor, I think that the difference is whether or not a party is doing so as an agent on behalf of the fee owner, the party that has the estate and the land, and whether that party.
So that's what we have to look at.
Exactly. And that is what I believe that the court has to look at is the distinction between whether or not the requisite authority is there to do so. And the next point I would like to make is regarding the collateral estoppel of a tenant from raising the lack of standing pursuant to RPAPL 721. just based solely on the fact that a lease agreement exists between the tenant and the petitioner. I think that when we look at the cases that are cited by the appellant or the appellee in this case, they really are factually distinguishable. Here you have a case from well in the past that they cite to that relies on the concept that when you're suing somebody in an action for money damages, or when you're suing somebody in some kind of plenary action not seeking possession, that you can't then deny the contractual relationship between them. But I think to come to the conclusion, for the trial court to come to the conclusion that a tenant cannot challenge a party's legal standing under a statute to maintain a summary proceeding based solely upon the lease agreement really is an error because there does have to be something more than just a signed lease agreement.
Question, does there need to be something more?
Yes, I do believe so. And I think that there's a case that we identify in in our submissions, this First Department case, Women's Inter Art v. New York City. And in that case, you have a similar situation. You have a piece of property owned by a fee owner, and that piece of property is then granted to a third party. The third party tries to evict a tenant inside of that property. And the First Department looked at the document that assigned the rights to the third party.
That's not what we have here. We have the same landlord, you know, with the contractual, contract with your client. You know, they collect the rent, they sign them up, they're named on. I guess I'm not seeing, there's a disconnect in the case you just said, where there's a transfer of ownership in the middle of this, so I don't think that's the same thing at all.
Well, Your Honor, I don't think that there is a disconnect. I don't think there's a transfer of ownership. There's the property in the First Department case, for instance, is assigned to essentially a property management company. And the First Department says in that case that if you look at the grant of rights that are given to this third party to maintain the property, you see that they were granted the right to exclusively lease the premises. They were granted the right to exclusively collect rents, maintain eviction proceedings. They bore the costs of utilities. They bore the costs of insurance. They bore the costs of all of the repairs.
I'm sorry, but let's just assume your client had a breach of a duty of warrant to habitability claim here.
Yes, Your Honor.
Who would they bring that claim against under this agreement?
I think that under this agreement, they would bring the claim against the individual that they signed the lease agreement.
In other words, your position is Minor Realty has a duty to provide a habitable leased premises. That's your position.
Well, I think that the problem is
that has to be the case if they're the landlord. They have a duty to provide a habitable apartment.
Yes.
But they don't have a right to bring a summary proceeding?
Not in their own name. They may be able to bring the summary proceeding in the name of the fee owner, the party that granted them the ability to maintain the property on their behalf. But the issue here is the recovery of the possessory interest in Minor Realty's own name and not in the name of the fee owner, where that possessory interest is going to revert to.
Counselor, this is kind of a random question. I couldn't remember the record. Is there anything in there indicating that your client was or was not evicted?
My client, so a warrant of eviction and a monetary judgment were issued and a judgment of possession, but my client is still in the premises.
Okay. Well, thank you very much for your arguments.
Thank you.
Appreciate it. Next is number 79, War Veterans Memorial Drive versus Michael Stores, Inc. Mr. Bucky is here, and we have counsel also, Julian Modesti is remote. Oh, God bless you.
Thank you.
Mr. Modesti, good morning or good afternoon, sir. Can you hear me okay?
I can, Your Honor. Good morning.
And we can hear you
Good
as well.
afternoon, sorry.
No problem. You don't have to be that technical. I just wanted to let you know that we're awake here and it's good afternoon. So, Mr. Bucky, you're ready to go?
I am, Your Honor.
All set.
Good afternoon, Christopher Bucky on behalf of Corps Veterans. Despite what the parties say in their briefs and their record, this isn't really about lease interpretation. Clearly, we disagree with the contention that somehow Corps was required to fill this Bed Bath & Beyond store in its entirety with one single tenant. The language of the lease doesn't say that. It shouldn't be interpreted that way. It's practically impossible.
It does say that, yes.
It does, but it's very clear, Your Honor, under 17.9 that singular is supposed to be treated as plural and vice versa. So, but there's also a practical consideration, Your Honor. There is just simply no national retail tenant who can fit its prototypical store into a 20,308 square foot space. They will have to reduce their store, the space for it in order to make this work. But then there's also just the practical consideration is that, and I think this is clear from the record, Michael's got not just the benefit of its bargain, it got more than the benefit of its bargain here when Corps takes a tired, failing home furnishing concept that had been failing for years and replaces it with two vibrant national retail brands. However, the court doesn't have to reach the issue of what 16.3 means. And that's because Michael's unequivocally signed off on these two vibrant national retail brands to go into the Bed Bath & Beyond space. When it signed the estoppel certificate in June of 2021, its right to this offset under 16.3 had long since fully matured. There's no dispute that Bed Bath & Beyond left its space almost 3 years earlier in 2018. And Michael's concedes that that's the triggering event, not entering into a lease with Old Navy and Spectrum. The triggering event under 16.3 is when Bed Bath & Beyond left in November of 2018. So there's no dispute there. And then there's no dispute that in the estoppel certificate, Michael's expressly represents that there are no offsets to the enforcement of the lease. So what we have then is Michael's isn't claiming that the estoppel certificate was procured by fraud or duress. Michael's is not claiming that there's any ambiguity. So then we look at what happened behind this. What's clear is Michael's entering into this estoppel certificate and making this representation, it was both intentional and fully informed. And what's clear from the record is Corps asked for the estoppel certificate. Michael's responds and says, first pay us $500 and maybe we'll give you one. But then they also say, we need our compliance department to review the current site plan of the center, which shows the tenants in the center and their square footage. Corps response provides that information, which clearly shows graphically that Old Navy and Spectrum are going into this space. There's no dispute there. The next day or several days later, Michael signs the estoppel certificate.
Counselor, even if that space is empty, that doesn't mean you're in breach of the agreement.
But we're not.
Right. So that the estoppel certificate doesn't say, I mean, whether their position could be that they can read this, that they have either option under this agreement on how what rent is due, depending on how you decide to lease that space. And it's your option how you want to lease that space. But if you choose to not have an anchor tenant, then you're going to pay less rent.
But Your Honor, Corps did not have an anchor tenant in that space as of November 2018. So it's not a question of whether or not it's a breach of the lease. We're not contending that.
Or a default.
We're not contending that it's even a default. Under the estoppel certificate, one of the representations is that there is no offset to the enforcement of the lease. Clearly, Michaels has asserted this now, the 16.3, as an offset to the lease. It's right to a reduced amount of rent. It had an absolute obligation to make that representation, Your Honor, when it provided the estoppel certificate because it knew of these stores. And its compliance department reviewed it, and clearly the compliance department made the determination that these stores satisfies the requirement under 16.3 to replace Bed Bath & Beyond. And then it's not a mistaken
But
representation.
moved in at that point?
Pardon me?
Had those stores actually moved in at that point?
They hadn't moved in, but Your Honor, still the Bed Bath and Beyond space had been vacant for almost 3 years. That it's not, the test isn't about what the replacement tenants are. The test is there a anchor tenant in that space? And there wasn't for almost 3 years. And that's what the problem is. And so, but further, even though they hadn't moved in, Michaels clearly knew they were moving in the very near future, and Core relies upon that, Your Honor. And Core does an enormous mortgage refinance, $20 million on the whole shopping center. Core spends $3 million plus to build out those 2 stores after it gets that representation from Michaels. And Core enters into long-term leases with those stores. But then Michaels waits and waits and waits until Core is locked in on those leases. Then Michaels says, oh, wait, 4 years later, now we have a 16.3 offset now, and Core's locked into long-term leases with Old Navy and Spectrum and can't do anything about it. And again, this wasn't a mistake on Michael's part, because when it signs the estoppel certificate, it actually had 2 offsets at the time. It also had this 3% percentage rent obligation under the amended lease. It only discloses that one in the estoppel certificate. And as we discussed in our brief, that creates an irrefutable inference that they intended to omit the 16.3. And quite frankly, they intended to be precluded from raising that in the future. So in the end, Michaels is left to argue that there's, a condition precedent wasn't met because the estoppel certificate wasn't delivered back to it in 90 days. We discussed this at length in the brief. The operative issue here is when Core countersigned the estoppel certificate, and there's no dispute that was 1 day later. And if there's any ambiguity there, it has to be construed against Michaels because it's their estoppel certificate in the first place. And in any event, they're only entitled to provable damages. They're not entitled to invalidate the estoppel certificate that they signed.
But counsel, does the language in the estoppel certificate indicating that in the event of conflict between it and the lease, that the lease would control?
Absolutely, it does, Your Honor, but there's no conflict here. What Michaels is making, and we've discussed a number of cases involving these, absolute application of an estoppel certificate. Michaels did not disclose. Michaels said affirmatively, there are no offsets to the lease. And the offset to the lease, as I keep saying, existed for almost 3 years at that point. They had never raised it at that point, and then they sign off on Old Navy and Spectrum. That's on Michaels. It's not on Core to do this. And as I've already said, the evidence about our reliance here is undisputed, both with respect to the refinance and the enormous investment Core makes in bringing in these 2 vibrant national retail brands. But in addition to this being about the estoppel certificate, this really is a windfall case because, as I keep saying, Michaels gets more than the benefit of the bargain now. The shopping centers improve because you have Old Navy and Spectrum instead of Bed Bath and Beyond in the court. We've all seen how bad it was with Bed Bath and Beyond for years and years before it closed. No one was coming to that store. There's no traffic. Now you have traffic. That's the purpose of 16.3. So Michaels gets the benefit of that, yet it also gets to lock Core in for 20 years for incredibly below market rent. Now they're going to save $4.2 million for an improved. It's not just that there's no prejudice here. They're going to get a $4.2 million.
What you're asking us to do, as I understand it, is to reverse with respect to 3 causes of action, correct? Just to get it.
Yeah, sure.
Okay.
That's right. And in the end, this windfall, it's untenable, and it wasn't contemplated by the party's lease, and it's not contemplated by case law regarding the estoppel certificates, which are uniformly applied, nor is it contemplated under basic principles of contract interpretation. Thanks.
Thank you. Mr. Modesti, you're up.
Good morning, Your Honors. Julian Modesti on behalf of Michaels Stores, Inc. Your Honor, what's effectively happening is Core wants the court to rewrite its lease. And it wants a judicial adjustment to its terms, and it's engaging in a sort of a pretzeling twist of analysis and fact distillation to try to get this court, and before this court, Judge Antonacci, to change the terms that it had provided. CORE is a sophisticated entity. They're a sophisticated commercial entity, commercial landlord across New York State. And the terms are what the terms are. And let me get to the real one that counsel keeps stating, that the estoppel certificate somehow represented by Michaels that it was in agreement with putting these anchor tenants in. That's not the case at all. What the estoppel certificate did, and Justice Ogden is absolutely correct, and that it stated the set of facts as they existed that day that it was signed, and that is all it did. Okay. And with regard to the particular language in there, that tenant does not currently have any defenses or offsets to the enforcement of the lease, to Justice Del Conte's point, that's absolutely correct. They did not have any defenses or offsets. By the way, an offset, Your Honors, is defined as both parties owe each other money, and the second party reduces its payment to the first party, the amount of the offset. So by way of example, if, and this is not the case, if CORE owed money to Michaels, let's say $100, and Michaels owes $1,000, then through the offset, Michaels would then owe $900. There is no offset here, and there is no defense either. The estoppel certificate was absolutely correct, because what Michaels did was exercise a right. Their right to go to the alternative rent if an anchor tenant was not put into that space. It's not a defense, and it's not an offset. Those are different things. And there is nothing in the record, and there will not be anything in the record you could find, because it doesn't exist, where Michaels expressly consented to the placement of these new land, or sorry, the two new tenants in the property, Spectrum and not Bed Bath. Sorry, I forgot the second one. But those tenants, there's no such representation. All the estoppel certificate does is say, do you agree that the lease exists as these terms exist, so that everybody can rely upon it in that situation? And they did. There is no requirement in the lease that notice be provided from Michaels to CORE when they want to exercise the ongoing co-tenancy rent provision. Number one, there's no time limit. There's no limit when they have to do it. If you become aware, Michaels, that you have the right to use this alternative rent provision, you shall notify us in 30 days. That does not exist. And they're asking you to insert something like that. In fact, Your Honors, the lease has a standard non-waiver, no latches provision in it, so that anything that you take some time to do that doesn't otherwise have a deadline is not waived and cannot be used for estoppel purposes. They want the Michaels, they want this court to find on Michaels that Michaels had to sit down and tell them what they were going to do in the future and all of their plans. They could have said and added into the estoppel certificate that, and Michaels agrees that the payment of rent will be this going forward, and some type of stipulation as to those terms. They didn't do that. Okay. They signed it as is, they returned it. They returned it late. It had to be, now this is another example where they want you to change the terms of the documents in this case. Okay. That it had to be executed and returned in 90 days. They want you to bifurcate it and have execution in 90 days without delivery in 90 days. How does anybody know if a document is effective unless it's delivered? Okay, you could sign it as one counterparty, put it in your desk.
That assumes that the estoppel certificate has any import. You say it has no import.
Well, yes, Your Honor, it wasn't effective. It was effectively void because they didn't comply with the delivery terms of it. So their reliance on this whole case is.
So my point is, Mr. Modesti, maybe I'm catching up and I'm behind here, whatever, but seems to me once you start talking about this 90-day requirement, you're assuming that the estoppel certificate does you harm. You're saying it does your client no harm whatsoever is your primary argument. Am I
correct? Two arguments here, Your Honor. If you want to accept it for the sake of argument only, it doesn't do us any harm because there is no defense or offset that we misrepresented. Number two,
that's what I've written down as what I think is one of your primary arguments.
Yeah.
Is that this is not a defense or an offset, it's a right to a rent reduction is one of your key arguments.
And it's a right to exercise an alternative rent payment provision, right?
Yeah.
Okay.
I think we have that point.
Okay. So, Your Honor, going on from that, then if you look at their anchor tenant, definition, it provides for one anchor tenant. We all know what an anchor tenant does. It's a big, desirable, popular national retailer who brings in foot traffic to the retail establishment. That's what it is. Okay. If they had in their terms of their own lease a tenant, one tenant. That's the terms that are expressly in there. They tried to put it together to make it, constitute an anchor tenant. I don't know how they actually contend with a straight face that Spectrum is an anchor tenant. People don't talk about it in the holidays on Black Friday. Let's go shopping to Target and Spectrum. It doesn't happen. They're not an anchor tenant by practical circumstances. They're not an anchor tenant under the own definition of their lease, Your Honor.
So on that issue as well, you would ask us to affirm the court's findings, correct?
Correct, Your Honor. What I ask, and I'll summarize respectfully, Your Honor, is Judge Antonacci got it absolutely right. He refused to rewrite the terms of the lease and the documents for the benefit of CORE, and I respectfully request that this court affirm those orders in that regard.
We appreciate your arguments, counsel. Thank you very much.
Thank you very much, Your Honors.
Next is number 80, Corgi, but according to my pronunciation, versus Cushman and Wakefield et al. And the appellant is remote, and then we have Ms. Hoffman here. Excellent.
Good afternoon.
Mr. Galley, is it?
That is correct, Your Honor. Good afternoon. Good afternoon, Your Honor.
Can you hear us okay?
I hear you loud and clear, Your Honor. Thank you.
Same here, and the floor is yours, sir. Go right ahead.
Thank you. May it please the court, Justices, Anthony Gali, Gali Law, PLLC, on behalf of the appellant, Kareem Corgi. You had that pronunciation correct, Justice Curran. And because I would suspect, second to last on the calendar, everybody's wanting to get lunch, I will zoom into the main issue as appellant sees it, and that is whether the lower court erred when it dismissed the plaintiff's complaint in its entirety based on an alleged accord and satisfaction document that only applied to one of the two contracts at issue in the motion to dismiss. And additionally,
on that point, I'm looking at the accord and satisfaction language. And by the way, you've waited your time. You want time to speak to us. We're going to listen within reason. But the language of the accord of satisfaction that I'm focusing on talks about, I'm going to pay you this amount, $30,000, to settle the matter and have the listing agreement completely terminated. It's my understanding.
That's correct.
That reference refers to the second of the two listing agreements. Am I right, Counselor?
Only. That's correct, Your Honor. There are two listing agreements.
And forgive me for continuing to talk over, just so I get the thought out and see whether or not I've got this right. But if you agree that listing agreement is completely terminated as to both of the properties that were subject to it, am I right?
When reading this document, yes, that's what it purports to say, and there would not have been the error that we're appealing is as relation to the other contract, Your Honor. I think it's difficult to say that Justice Lamandola erred in dismissing the claims that stem from that contract, but he did err when he dismissed the claims that stemmed from the other contract.
And I didn't do that work with respect to the tax-free exchange, Section 1031. I know just enough to be dangerous, but if I understand your essential contention, and if I got this wrong, please let me know, that your client wants to say, at least with respect to the Hawley property and the Bellevue property, and maybe all the properties, I don't know, and that'd be good to know, that if the defendants had done their job properly, not breached duties, whatever, that exchange could have been effectuated to the tax benefit of your client.
That's correct. That is correct on a couple levels as well, Your Honor. So you'll notice that on the listing agreement that contains Hawley and Bellevue, those two properties, there were a number of others that were crossed off and then initialed as deleted. And it stems back to just how the defendant acquired my client to begin with, which was my client, and the verified complaint is detailed as to this history. My client approached the defendant to purchase a property. He wanted to purchase.
Just so you know, the facts we know well, the complaint is detailed. It's set forth the history and how it came about. But and if I'm oversimplifying, I apologize, but am I generally on track with respect to why this lawsuit is here?
I think you are, Your Honor. Yes. And I think as a matter of this appeal, what we're asking for is for it to be reversed and remanded to work out the remaining issues pertaining to the contract that was not settled. And there's an issue of how that accord and satisfaction was procured to begin with. Very unusual circumstances where the defendant actually comes to my client's home and with the context already have been established that there were oral conversations between the parties that the listing was canceled.
Counselor, if I could, as I understand it, there's sort of, in my view, there's sort of two separate claims here. One of which is your position is we shouldn't pay the commission, or we shouldn't have paid a commission on the Blossom transaction because Pyramid didn't earn a commission. But then you've got this, really, it's your first cause of action, the breach of fiduciary, that we had an arrangement where we were going to bundle some properties. Plaintiff had some property, I'm going to bundle those together, try to sell those, and then pick up East Genesee Street and do a 1031. And so you've got sort of two separate sets of claims and two items of damages. What I would have gotten if the 1031 went through, that's one claim. And then the other claim is I shouldn't have to pay the $30,000 or $60,000 in commission.
You could fairly parse them out as two different claims like that, Your Honor. Correct. And I think that's what the lower court ignored, was that there are.
But and just to top that off, your position is the accord and satisfaction doesn't touch my breach of fiduciary claim. That's
right.
If you characterize the May 23 agreement as accord of satisfaction, that's fine, but it doesn't negate my 1031 claim.
That's correct, Your Honor. That should not have been dismissed.
And does the fiduciary duty breach allegation, does it encompass the properties that are the subject of the second listing agreement? It seems to me if you take the position that that listing agreement is terminated, doesn't that include whatever fiduciary duties would have arisen out of that agreement, or no?
Well, it could, Your Honor, relating to the agreement for the properties. Let me put it this way, not for the agreement concerning Hawley and Bellevue. But for the other agreement, yes. However, we did allege that there was a special advisory relationship that imposed the fiduciary duty beyond what was articulated in the agreement. And even further to the agreement, there was an immediate cancellation, or I should say release of the agreement orally, that never made its way reduced to writing until this visit to my client's home, where there was a discussion of, we need to cancel this agreement. It was on a dormant.
I'm confused by something you just said. I didn't think the law permitted you to allege the fiduciary duties beyond the scope of the agreement. That is,
it does, Your Honor, when there's a special relationship, and that's what we've alleged. And that's okay. And the brief touches on the special relationship, and the assets are unique, Your Honor, especially Bellevue. It has cell towers on the top of it, so it's actually not a like kind exchange. He never would have been able to accomplish it, according to certain legal opinions we've obtained. This is a little bit outside the record, but the bottom line is it's not just real estate. It is a piece of real estate with cell towers on top of the real estate, which my client was advised to package with a bunch of real estate in order to accomplish a 1031 exchange. And this is where the representations of experience with cell towers, experience with owning cell towers and selling cell towers, that was impressed upon my client to create that special advisory relationship that my client relied on, and which we allege was breached, aside from the contract obligations, Your Honor.
Okay.
And we're asking that it be reversed and remanded, Your Honor.
Right. Thank you very much, Counselor. We're going to move to the respondent.
Thank you, Justices.
May it please the court, Elizabeth Hoffman, Costello, Cooney, and Fearon on behalf of the respondents. I'll kind of hone in on some of the issues that you've raised with regard to the appellant's arguments in the interest of time. The documentary evidence that was put forward to the court below was not only the accord and satisfaction, but it was also the exclusive listing agreements themselves, the contracts which defined the scope of the relationship between.
Let's start there. You don't disagree that there's a fiduciary duty between your clients and the plaintiffs?
We do not. We concede that as real estate agents, there is.
And so at this stage of the litigation, pleading stage, to set forth a claim for breach of fiduciary duty, you got to allege a duty, and you concede that, and then you got to allege some misconduct results in damages. And your position is somehow the listing agreement, the listing agreement conclusive, unequivocally resolves that issue about misconduct that's alleged in the complaint?
The issue that underscores the entirety of the problems that the appellant has is that the problems that are being pointed to are outside the scope of what Pyramid Brokerage was retained to do. The agreement does not say any more than we've agreed to list.
I understand that. I understand that argument, and that may be a winner later on, but this is your motion is at 3211. That the documentary evidence alone established that there was no breach of a fiduciary duty?
The documents alone do not rise to the level of the special relationship being alleged here, which the appellant moments ago conceded were outside the scope of the record and the documentation. So if you're confined to the four corners of the contracts themselves and what is contained in them, yes, I believe that the appellant is foreclosed at this juncture because he's limited to the scope for which my client was retained in the first place.
What I'm focused on, Counselor, as you probably figured out from my question, was the language of the accord of satisfaction upon which you rely seems to be limited by its express terms to only the second listing agreement. But the court nevertheless, as I understand its decision, dismissed the entire case as to both listing agreements. That strikes me as potential error.
I don't believe the court relied entirely on the accord and satisfaction for dismissal of the remaining cause of action. I believe that the court, and this is obviously my interpretation, relied on the exclusive listing agreements and the language contained in them for the breach of fiduciary duty.
Forgive my further interruption, but
yeah.
I think I'm quoting from the court's decision that the defendants have provided the accord of satisfaction which resolved the controversy between the parties with respect to their prior contractual obligations, plural. That's what I'm stuck on.
So, and a fact that I would point to is when the accord and satisfaction is executed, the prior listing agreements had already expired. My client was under no continuing obligation at that point. What continued here was because of the fact that the one property was sold.
But even though they expired, there may have been fiduciary duties that arose through them that continued to, that the breach thereof harmed even after the expiration. That is, the harm occurred by the failure to do the 1031, but it doesn't, as long as they're within the statute of limitations, can't they still sue for fiduciary duties?
Yes, as they're defined by the contracts. Which then goes back to my point that the contracts themselves don't extend to the level that the appellant is asserting they do.
But if the court did dismiss the case with respect to the first listing agreement based on the accord of satisfaction, it sounds to me, I'm going to push you a little bit here, that you would agree that was error.
I would agree that there are other bases for which the court dismissed those claims.
Well done, Counselor. Thank you.
Thank you.
Okay, next and last is number 80.1 in the matter of no appeal. And we have Mr. Babylon, I believe is here, Ms. Cuomo and Ms. Cagnina are both no. And if I've mispronounced, please forgive me.
You pronounced my name perfectly.
I did, I got it.
Thank you.
Well, I got a third right so far. I feel like the Hall of Fame on that one. Let's see, next in line is Ms. Cuomo. Can you hear me okay, Ms. Cuomo?
Yes, Judge, thank you.
And we can hear and see you just fine. And pronounce your name for me, please. Wait a minute, Ms. Cagnina?
Yes, that's correct, Your Honor. Thank you.
Please forgive me if I didn't get it right, but we can hear and see you just fine. So you're going to let Appellant's counsel, go right ahead.
Thank you, Your Honor. May it please the court, Thomas Babylon on behalf of appellant Anthony F. Anthony is a father that has really tried to have his son returned to him. And if this case is looked at objectively, you will see that this child was not returned due to the repeated failures of the mother and the department's failure to address that issue. The first point I'd like to discuss is that the agency failed to prove by clear and convincing evidence that it exercised diligent efforts. The agency is required to identify barriers to reunification and make affirmative, repeated efforts to overcome those obstacles. Here, it failed to identify that Anthony's continued relationship with the mother was a barrier to reunification, to counsel him how to care for a child with a parent with mental health illness, or to advise him to terminate his relationship with Ashley when she refused to engage in services. Diligent efforts requires that the agency provide services to improve a father's understanding of a mother's mental health needs and to help him care for a child in a home where the mother has a mental health illness, or to counsel him that the relationship is a barrier to reunification when the mother is unwilling to address the underlying issues that led to the removal. Here, the agency was well aware of the mother's mental illness and of her refusal to engage in services, and yet did not counsel Anthony as required by the case law. Her mental health was in such poor state that it prevented her from visitation often, and she was left visitation many times in an ambulance. Her anxiety caused her chest pain and breathing difficulty, and she had irrational thoughts that people were trying to kill her. She yelled and screamed at visitation sessions, and things were so bad that both parents' visitation were cut in half. And although the agency urged her to seek services, she repeatedly refused to engage in them. At the end of this proceeding, she had completed none of her services, while my client had completed everything except getting a clearance from visitation.
Wait, did he complete his mental health?
Well, Judge, that's interesting because there was no referral for mental health in the record. There was a psychological evaluation that was prepared. The agency determined not to introduce that into evidence. There was a caseworker testimony regarding that psychological exam, which was objected to. That did come in over the objection, but the record is deplete of any referral for mental health care, Your Honor. There was a recommendation in the letters that said, I would like you to see a mental health specialist, the case worker, but there was no referral from a professional. And in fact, the record shows that she never went over the referral. There's no notes regarding her reviewing the referral with my client or giving it to him. So he, in essence, had no idea what was in that referral. So here the agency did nothing to address the mother's issues, and this was critical for Anthony to be unified with his son.
So do the mother and father live together?
That's correct, Your Honor. And here the agency had an obligation to counsel my client that could preclude him being reunified with his son, which they did not do. So when asked about counseling the parties to live apart, the caseworker in this particular case said she had not provided that counseling. And as far as she knew, no one at the agency had, and she did not think that that was her role to have that conversation. And even if we were to accept the arguments of the AFC and the county that the visitation supervisor once tried to have that conversation with the parents, such a one-time unplanned remark cannot be considered affirmative and repeated efforts. Diligent efforts also require the agency to investigate potential relative placement of the child. Here, two potential relatives actually contacted the agency, made multiple calls to the caseworker, and when the mother, they were relatives of the mother, when the mother inquired as whether the caseworker had spoken to them, the caseworker responded she was not going to waste her time speaking to the potential relative caregivers. Because diligent efforts were not shown here, the lower court should have dismissed this petition, and we ask this court to do the same. The second point I'd like to discuss is that the agency failed to prove by clear and convincing evidence that my client failed to plan. Anthony completed every service that was requested of him and attended almost every visit. And here, many of the court's findings with regards to his failure to plan were rebutted by the documentary evidence, and as such, cannot satisfy a clear and convincing.
I think part of that, Counselor, was he didn't have a safe and secure home for the child.
Well, I mean,
that was a big issue.
And part of the reason he didn't have a safe and secure home, Your Honor, I would argue, is because the agency never counseled him to get residents separate and apart from the mother.
To get a bed for the child?
I'm sorry, Your Honor?
I don't even think there was a bed for the child.
There were several residences in this particular case, Your Honor, and the last residence, at the time of the dispositional hearing anyway, the caseworker had not visited that residence in 5 months. It was a new residence and there was not furniture at the time, but my client had explained to the caseworker, we're getting furniture. So there was no, I mean, there was a new place. But in regards to the failure to plan, the court faulted my client for not engaging his son at clinical visitation. But the visitation notes show that he actively engaged the child on multiple occasions in multiple ways. Sometimes he was less engaging when the mother came to visits because he allowed her to have time with the child. But the notes discuss many instances of him talking to the child, playing with the child, and thus the court's finding that he rarely interacted with Noah at visits is without a basis. The court also blamed my client for parental conflict at the visitation, which was also not supported by the evidence, as what the evidence showed was that the mother was the aggressor, often yelling and screaming at him while he remained calm. Domestic violence classes. The court faulted my client for not changing his behavior after completing the classes, but there was no evidence of any instances of domestic violence during the relative time period. And the testimony from the the visitation supervisor was clearly that the mother would yell and scream at him and he would remain calm and not react violently. And while Ashley yelled and screamed, the one reference instance that the caseworker mentioned was that she heard my client in the background of a phone call was before the relative time period. In fact, it was the initial residence that the parties had lived in and before he had completed domestic violence classes. They faulted my client for failing a drug test when he clearly told the caseworker, the case notes reflect this, that several days prior to the drug test that he'd been in the hospital and he'd been prescribed an opioid. She then gave him the test. And then when she confronted him with the positive results, he said, I had a prescription. There's nothing in the record indicating that she requested confirmation in that prescription or that he had been referred to substance abuse treatment. In fact, he went to substance abuse evaluation. And what the case notes or what the letters reflect is that there was no referral for substance abuse treatment. And they also faulted my client with not engaging in mental health treatment, as you had previously brought up. There's nothing in the record with regard to such a recommendation. The only thing was the caseworker's hearsay testimony about the report, which was objected to, and which the court said, well, I have to let her testify about it because they might introduce the report at a later date, which they didn't, even though it was subpoenaed. And the court finally faulted my father for not accepting his responsibility for the child being removed. And they said this was because he blamed the mother for the child not being returned. But there was a sound basis for this belief, as he had completed nearly all of his services and the mother had completed none. She continued to use drugs, she continued to do prostitution. And the failure here was with the agency's failure to not discuss that issue with Anthony, that the mother was not doing these services and that they couldn't get the child back. It wasn't my client's, it didn't show that my client was not accepting his responsibility by pointing out that the mother was not accepting hers.
If I'm reading this correctly, Mr. Babylon, it seems to me you've kind of gone in order of the most significant arguments that you want. That is, your main argument is where you started, the diligence efforts, and then the failure to plan.
Yes, sir.
The hearsay thing is kind of, that gets you maybe a new trial, perhaps, that kind of thing. But anything else with respect to your arguments?
Nothing, Judge. Actually, I'm finished. The only thing I'd like to say here is that, because this agency failed to meet their clear and convincing burden as both diligent efforts and failure to plan, we just would request that this court dismiss the petition. Thank you.
Thank you very much. Ms. Cuomo.
Good afternoon. Lisa Cuomo on behalf of the Onondaga County Attorney's Office. Judge, I just would note that as Mr. Babylon indicated, he continued to reside with the mother while she continued to use substances and engaged in prostitution. So that certainly points to his ability to understand what's a safe and stable environment for a child. With regard to him trying to kind of backdoor and say, well, if someone had told him that he didn't live with her or reside with her, that he would have had a better chance, I'm going to draw the court's attention to Dr. Lehman's testimony from the Huntington Center that he would not have been able to parent on his own. And she took into consideration his low IQ and also that he was unable to understand the developmental stages of the child. He never graduated from the supervised visitation, even after he and the mother's visitation were severed, because they could not visit with the child at the same time because they caused too much of a commotion while they were there together. So he did have an opportunity to prove that he could successfully parent the child on his own during his own visitation, and Dr. Lehman indicated that that was not possible. Also, there was testimony by Dr. Lehman that she tried to talk to him about his continued living with the mother, and he was not interested in having any conversations in that regard. With regard to the department sustaining its burden, I would submit that there's more than enough testimony here that Sir was not capable of parenting the child by himself. He never graduated from supervised visitation. There was testimony that he was not learning anything from his domestic violence classes, and he tested positive for opiates. So unless any other questions, I'm all set.
Hearing none, we're all set. We'll go to the AFC. Thank you very much.
Good afternoon, Your Honors. Christina Kagina for the subject child. I would support the county's position at this point. There's several issues that were brought up by appellant that are not borne out by the facts in this case. The record is replete from the beginning of these proceedings, even prior to the termination, that numerous efforts were made throughout the proceedings to address the severe imbalance in behaviors between the parties. And it appears it's very consistent with Sir's position that he held while he was in court, that this was none of it was his fault and that none of it was his responsibility. Yet he continued to reside with the mother. He continued to reside in unstable and unsafe housing for the child. I would note he did not progress in any of the supervised visitation, not because he didn't engage, but because he engaged in behaviors that were unsafe for the child, such as bringing inside unsafe toys. And in fact, when confronted many times by many service providers regarding some of these behaviors, he either ignored them or told them he wasn't going to take their direction. And I think that that is consistent with the issues that are raised by the appellant, that repeatedly caseworkers and service providers attempted to make these connections and make these referrals and make these efforts for the family. And specifically, the father was aggressive in his refusal to do so and refusal to cooperate with the department.
Where is the child now?
Still with the foster family that is waiting to the foster mother. that
Okay,
is
so he's
waiting
in a
to adopt.
pre-adoptive home?
Yes, and he has been since he was removed.
And how old
directly
is
to
he
that
now?
home. He's 6.
Did you ever observe the child and the father together? Any interaction between the child and the father or the child and the mother? Did you, as the AFC, ever see that?
I observed it at the initial removal. I was there at the initial removal, and there was one visit that occurred. It wasn't necessarily a visit, it was a transfer that occurred later on that I did see. The child is a sweet young man who has some intellectual limitations. I didn't see any fear or concerns regarding the child, but the child at that point, the initial removal, I believe he was a little over 1.5 years old. And at the next interaction I viewed them at, he was about 2.5 years old.
Okay. Counselors, thank you very much.
Thank you, Your Honor.